Hear ye, hear ye. All persons having business before the
The
Honorable
clerk of court will please call the matter at hand.
Yes, Your Honor. GR number 234359, Aileen Almora et al. Versus Director General Ronald De La Rosa et al. And GR number 234484, Sister Maria Juanita Ardaño, RGS, RSW et al. Versus the Philippine National Police, represented by PDG Ronald De La Rosa, Chief Philippine National Police et al. Appearing as counsel for petitioners in GR number 234359 are the following: Attorney Jose Manuel I. Jocno, Attorney Pablito V. Sanidad, Attorney Alexander Padilla, Attorney Felix J. Marinas Jr., and Attorney Pablo F. Sanidad II. Appearing as counsel for petitioners in GR number 234484, Attorney Joel Ruiz Butuyan, Attorney Roger R. Rael, Attorney Gilbert Teruel Andres, Attorney Ethel C. Avisado, and Attorney Sarmar C. Garcia, Attorney Cristina I. Antonio, Attorney Gil Antonio E. Aquino, Attorney Crispin Francis M. Handusay, and Attorney Kimberly Ann M. Lorenzo Andres. Appearing as counsel for public respondents from the Office of the Solicitor General, Solicitor General Jose C. Calida, Assistant Solicitor General Renan E. Ramos, Assistant Solicitor General Rex Bernardo L. Pascual, Attorney Crispin Francis M. Assistant Solicitor General Maria Cielo C. Rondain, Kimberly Ann M. Assistant Solicitor General Mirna M. Agno Canuto, from the Assistant Solicitor General Marisa Macaraig Guillen, and Assistant Solicitor General Henry General Renan E. Ramos.
Thank you, counsel for respondents. Will please take their seats. While I will request Attorney Jocno, please, to approach the podium and explain to the court how you will divide the time between you. Both sides have already, of course, received the oral advisory, correct? Okay, please, you can take your seats.
Thank you, Your Honor. Good afternoon. I conferred with Attorney Butuyan yesterday, and we decided to divide the issues as follows. I have already sent an email to the Clerk of Court of the Honorable Court informing her of the division of issues. On the main issues, Your Honor, both of us will address both main issues. On the procedural sub-issues, Attorney Butuyan will take care of letters A and B, whether a class suit is proper and whether petitioners have standing to file the petition, because in the comment, it was their standing that was questioned. I will take care of letters C and D, that is whether the Supreme Court has jurisdiction over the instant petition and whether a petition for prohibition and amparo can be joined in one petition. For the last two procedural sub-issues, letters E and F, both of us will have to address that because the arguments of the Solicitor General pertain to both petitions. As far as the substantive sub-issues are concerned, I will take care of letter A, whether the PNP and the ILG circulars have legal basis, and Attorney Butuyan will take care of letter B, whether the acts authorized or conducted under the authority of these circulars violate the Constitution and several laws and administrative provisions. As far as the letter C is concerned, whether the acts authorized or conducted violate the ICCPR and the Minnesota Protocol, among others, Attorney Butuyan will take care of that. And as to the last sub-issue, whether petitioners are entitled to the interim reliefs prayed for, both of us will address that issue, Your Honor.
You will divide the 20 minutes equally.
It was my understanding, Your Honor, and we had prepared for a presentation each of 20 minutes. If we may be allowed to that time.
So can you find a way to condense it to...
We can extend it to 15 minutes each.
All right, 15 minutes each.
I will,
Please do with that.
I will do that, Your
Okay,
Honor.
it's 40 minutes of continuous presentation might be too much for us. And then after both of you have consumed your respective 15 minutes, then we will immediately proceed to the interpellations of the justices.
Thank you, Your Honor.
Okay, okay, please proceed, Attorney Jokno.
May it please the Honorable Court. The cases at bar raise many issues before this Court. The advisory for today's hearing enumerates 2 main issues, 6 procedural sub-issues, and 4 substantive sub-issues that counsels are supposed to address. Despite the many issues, however, we should not lose sight of the ultimate question that this case presents to this Court, which is this: will the Honorable Court allow the government's war on drugs to supplant justice from the courts with justice from the barrels of guns? Petitioners Eileen Almora, Rowena Apari, and Jefferson Soriano are directly aggrieved by the war on drugs. Eileen Almora's brother, Ryan Dave, was killed in an alleged buy-bust operation after he was listed as number 3 on the watch list, level 1 of the illegal drug personalities of the Baguio City Police Office. Rowena Apari's son, Rex Apari, was killed in a Tokhang operation in Tondo, Manila, after armed men invaded his home without a warrant. Both of them were killed allegedly because they resisted the police or nanlaban. Petitioner Jefferson Soriano, on the other hand, was shot and left for dead after he had been picked up by the police and tortured to reveal the whereabouts of someone who was wanted by the PNP. Ryan Dave Almora, Rex Apari, and Jefferson Soriano are just 3 of thousands of Filipinos whose blood has been spilled on our streets because of the war on drugs, most of them in areas mired in poverty. But the war on drugs, Your Honors, is not just killing the poor. It is killing our legal system by replacing justice from our courts with justice from the barrels of guns. That is why we have come to this court and pray for the court's intervention. The government's war on drugs began on July 1, 2016, when newly installed PNP Chief Ronald De La Rosa issued Command Memorandum Circular 16-2016, unveiling Project Double Barrel, a 2-pronged approach to combating illegal drugs. CMC 16 is unique in the annals of law enforcement. Instead of directing the police to apprehend and prosecute drug users and pushers, it expressly commands the police to neutralize and negate them. Instead of directing the police to redouble their efforts to gather evidence to convict drug users and pushers, it orders the police to compile names of suspected quote-unquote illegal drug personalities for the purpose of neutralizing and negating them. Instead of directing the police to obtain search warrants from the courts in order to raid the houses of these illegal drug personalities, it requires them to conduct warrantless house-to-house visitations and to negate those who deny or refuse to be visited. Based on PNP Chief De La Rosa's 1-year report, the government's war on drugs, as operationalized by CMC 16, has resulted in the deaths of 3,264 so-called drug personalities and 141 so-called high-value targets, not to mention the thousands of others killed by death squads who roam our streets with impunity. Never in the history of our country has this happened before. It is our hope that this court will see to it that it will not happen again. CMC 16 clearly and repeatedly orders the police to neutralize and negate suspected criminals. I quote directly from the circular in question, from pages 1 and 2, quote, "This command memorandum circular sets forth the general guidelines, procedures, and tasks of police officers in the conduct of Project Double Barrel in support of the barangay drug clearing strategy of the government and the neutralization of illegal drug personalities nationwide." From page 3, the PNP intends to equally address illegal drug problems in the barangays and at the same time pursue the neutralization of illegal drug personalities. From page 15, the PNP will conduct intensified anti-illegal drug operations by focusing on the neutralization of street-level drug personalities. From page 16, tasks, focus teams, neutralize high-value and street-level targets to include their support system, drug lords, their protectors, coddlers, and supporters. From page 5, Any person suspected to be involved in illegal drug trafficking who denies or refuses the house-to-house visitation shall be referred to the anti-illegal drug units for immediate negation. And from Annex A of the circular, continuous conduct of house visitations and referrals for negation. Unlike arrest, search, and seizure, however, Your Honors, neutralization and negation are not legal terms. They have no counterpart in law. But in police parlance, as used by no less than the chief of the PNP himself, to neutralize means to kill. On September 28, 2016, PNP Chief De La Rosa told the press, and I quote, "We have received information na itong general na mayayaman na ito nakapag-ipon na ng pera na pinagpopondohan na kami para ma-neutralize." On November 14, 2016, PNP Chief De La Rosa publicly announced, and I quote, "Mas ipaprioritize ko yung pulis na nangungurakot sa inyo, ipaprioritize ko silang in-neutralize." Continuation of quote, "I will neutralize them." Kaya warning ito sa mga pulis natin na umiikot dyan. Ginagamit yung war on drugs para sa pangungutong. "I will break your neck," literally. Babaliin ko yung leeg nyo, literally yan. Tingnan natin, he said. When Chief De La Rosa told the public that drug lords were putting up money to have him neutralized, he obviously did not mean that they were going to have him arrested or prosecuted. He meant only one thing, and that is that they were out to kill him. When Chief De La Rosa publicly warned the police that he will neutralize them and added in the same breath that he will break their necks, literally, he obviously did not mean that he will arrest them or put them in jail. He obviously meant that he would literally break their necks. Speech, as the saying goes, is the index of intention. These public declarations by Chief De La Rosa are not hearsay. They are extrajudicial admissions that are admissible under Section 26, Rule 130, which provides that the act or declaration of a party as to a relevant fact may be given in evidence against him. As this court held in People v. Andan, statements spontaneously made to news reporters in a televised interview are deemed voluntary and are admissible in evidence against the party who made them. But that is not all. The PNP itself, in at least one Oplan Barrel report, used the term neutralize to mean kill. I quote, "Neutralize is better. PNP ditches kill term in Oplan Double Barrel report." The Philippine National Police has removed the term killed in its latest update on the number of drug suspects slain in police operations. The PNP's update on the progress of the Oplan Double Barrel on Tuesday used the word neutralized instead. In its latest report on Oplan Double Barrel, the PNP said a total of 1,661 drug suspects have been neutralized and 29,910 have been arrested in 31,215 operations conducted from July 1 to 6 a.m. of October 18. CMC 16, in other words, expressly authorizes the police to kill suspected illegal drug personalities in the guise of neutralizing or negating them, without the benefit of a trial and without due process of law, in violation of the Bill of Rights. But that is not all that is wrong with the circular. Under Section 24 of Republic Act 6975, the PNP is mandated to investigate and prevent crimes, arrest criminal offenders, bring offenders to justice, and assist in their prosecution. Instead of fulfilling this mandate, CMC 16 does away with the gathering of evidence for the appreciation of the courts and replaces it with the compilation of names of suspected drug personalities for the purpose of neutralizing and negating them. CMC 16 directs all police units nationwide to, quote, maintain updated watch, target list, wanted list, and most wanted drug traffickers. It creates monitoring centers on the national, regional, provincial, district, and city levels to collate these lists and to maintain a database of these lists, and requires the Directorate for Intelligence to conduct monthly workshops to generate and provide updated watch list, target list, and wanted list on the illegal drug groups and personalities. From the time this circular was issued, these lists have formed the backbone of the PNP's war on drugs. But we submit, Your Honor, Your Honors, compiling names of suspected criminals is very different from gathering evidence against them. Gathering evidence entails getting statements from witnesses with personal knowledge, obtaining physical evidence, and building up a case for presentation in court to secure a conviction. The safeguards in the gathering evidence are built into the system, for it is the courts that will decide if the evidence is admissible or not. The process is transparent and done publicly. Under CMC 16, however, anyone can submit a name to the PNP even if they have no personal knowledge of that person's involvement in illegal drugs, even if they merely believe or suspect, rightly or wrongly, that that person is involved in illegal drugs. And there are no adequate safeguards because there is no neutral third party like a judge that will determine if the names should really be on that list. While CMC 16 states that the list shall be validated, the validation is internal, it is done in secret, and there is no mechanism for having your name removed once it appears on the list. These watch lists, target lists, and wanted lists are still in the possession of the PNP and pose a grave danger to the life, liberty, and security of the persons whose names appear on those lists. Persons, I must emphasize, who are presumed innocent because they have not yet been proven guilty before a court of law. And because these lists are secret, Your Honors, anyone's names, even those who are here today, could find their way into these lists and they would never even know it. Which is exactly what happened to petitioner Eileen Almora's brother, Ryan Dave Almora, who was number 3 on the watch list level 1 of the Baguio Police. Once his name was on the list, he became a target, and in his case, he ended up dead. There is a third reason, Your Honors, why CMC 16 is unconstitutional, and this is because the house-to-house visitations it directs under Project Tokhang are based on mere suspicion and the furtive fingers of unknown informants, are meant to circumvent the requirement of a search warrant issued by a judge, are offensive to the presumption of innocence, and are not meant to persuade drug offenders to stop their illegal drug activities, but rather to negate those who deny or refuse the visit. By requiring the PNP to conduct warrantless house-to-house visitations of suspected illegal drug personalities, Tokhang violates Article 3, Section 3 of the Bill of Rights, which requires the approval of a judge before a house can be invaded by the police. By commanding the police to persuade suspected illegal drug personalities to stop their illegal drug activities, Tokhang concludes that suspected criminals are already guilty. For why else will they be persuaded to stop their illegal activities if they are not guilty? Tokhang therefore violates the presumption of innocence and usurps the judicial function of determining the guilt or innocence of a suspected criminal. Since Tokhang does not require evidence to be presented to a judge for the issuance of a search warrant, it gives the police unbridled discretion to enter people's homes in violation of the constitutional requirement of probable cause. The fundamental protection accorded by the Search and Seizure Clause, according to this Honorable Court in People v. Aruta, is the protective authority of a judge who stands between the person and the police and who decides if the police may intrude into the sanctity of our homes. Tokhang takes away that fundamental protection. Based on official PNP reports, Tokhang has resulted in the warrantless visitation of 7,790,765 homes. But that is not all that is wrong with Tokhang as provided by the circular. By directing that any person suspected to be involved in illegal drug trafficking who denies or refuses the house-to-house visitation shall be referred to the anti-illegal drug units for immediate negation, the circular can easily be construed as authorizing the police to take shortcuts to negate uncooperative residents, even if these shortcuts violate the constitutional command that no one may be deprived of life, liberty, or property without due process of law. The Solicitor General argues in his consolidated comment that PNP Chief De La Rosa had the authority to promulgate CMC 16 under Section 26 of RA 6975, which provides that the PNP chief shall have the power to direct and control tactical as well as strategic movements, deployment, placement, utilization of the PNP. I beg to disagree. CMC 16 does not merely direct and control tactical as well as strategic movements, deployment, placement, and utilization of the PNP. It radically alters the mandate of the police. It authorizes extralegal killings and home invasions without a search warrant, and tramples on basic rights enshrined and guaranteed by our Constitution. As such, CMC 16 exceeds the authority of the PNP chief and therefore is ultra vires. The same is true, Your Honors, please, for the ILG Memorandum Circular 2017-112, which establishes a system for the anonymous reporting of suspected drug users and drug dealers in every barangay. While the DILG head is empowered under EO 292 to promulgate rules and regulations, the rules that they issue must be consistent with the Constitution and existing law. MC 112, like CMC 16, violates the Constitution and existing laws by allowing any Tom, Dick, and Harry to anonymously report suspected drug users and pushers. It institutionalizes what CMC 16 operationalized, a nationwide system of unknown informants whose furtive fingers could point to anyone. There's one other ground, if Your Honor, please, that we just actually discovered very recently, and it is that PNP 16-2016 and the ILG MC 112 were not filed with the UP Law Center. I have with me, if Your Honors, please, official copies of the certifications from the UP Law Center to that effect, as well as photocopies which we will provide to the Honorable Court. May I know how much time I have left?
Attorney Anama, how much time does Attorney Jokno have? Pardon? It's time already.
May
actually.
I just be allowed to wrap up, Your Honor?
Yes, please do that.
The revised PNP Operations Manual contains a quotation from John Marley, where he says, and I quote, "It is not enough to do good, one must do it the right way." The war on drugs we submit as operationalized by PNP CMC 16 and institutionalized by DILG MC 112 is not the right way to fight crime. The only true and lasting solution to rampant crime is to strengthen our justice system, not to supplant it with justice that emanates from the barrels of guns. Fear of drugs and the use of violence to suppress it are powerful motives but unreliable guides. They can create evils more monstrous than those they seek to avoid, as monstrous as killing the poor and destroying our justice system. Thank you, Your Honors.
Thank you, Attorney Jokno. Attorney Butuyan, please proceed with your presentation.
Good afternoon, Your Honors. May it please the Court. Your Honors, the outline of my submissions will be as follows, and they traverse the issues identified by this Honorable Court. Number one, the government admits that state agents are involved in thousands of deaths resulting from police operations, and these killings are anchored on a government circular. Number two, the highest officials of our country have encouraged the police to do more killings, and they have assured the police of protection and pardon. Number three, Command Memorandum Circular 16-2016, which is the basis of police operations that have resulted in thousands of killings, violates the Bill of Rights, statutes, and administrative rules. Number four, there is an ongoing war against the Bill of Rights in our Constitution. Number five, the implementation of the Memorandum Circular on a nationwide scale endangers the rights to life, liberty, and security of all citizens of the country, and most especially all the residents of San Andres Bukid. Every resident, by way of a class suit, has the right to seek for protection for a collective or community writ of amparo. Your Honors, the Supreme Court, in its 116 years of history, has never been confronted with a case of this magnitude and importance. Never in our history as a people has it happened that state agents, our policemen, have admitted to being responsible for thousands of civilian killings. And never in our history as a country has thousands of killings been justified on the basis of a government circular. In all the previous Amparo cases brought before this honorable court, the participation of state agents in the killings or disappearances was vehemently denied by police and military forces. And there were no government circulars upon which the killings or disappearances were anchored. In this case, however, state agents themselves admit to having caused thousands of the killings. And there is a government circular that is invoked as basis for all these police killings. By the own admission of the Philippine National Police, 3,800 suspected drug personalities were killed by policemen in police operations they conducted from July 2016 to October 2017. These numbers are very conservative because of the following. Number one, they do not include vigilante killings, many of which are suspected of being perpetrated in conspiracy with or upon the directive of police forces. Number two, they do not factor in the fact that private organizations have counted the number of killings to more than 13,000 already. But even with these 3,800 deaths in the hands of policemen, this number of killings has already surpassed the 3,200 deaths during the entire 9 years of martial law under the Marcos dictatorship. In the San Andres Bukid community that we represent, the number and the nature of the killings are as follows. Number one, of the 35 deaths documented in our petition, 23 deaths were at the hands of policemen. That's 60% of all the deaths. Number two, of the 23 police killings, 19 were killed in alleged and supposed buy-bust operations conducted by policemen of Manila Police Station 6. Number three, of the 35 deaths, 21 were killed either inside their own home or in the home of other slain victims. Number four, of the 35 deaths, 24 were killed during a quote-unquote kill time pattern period from 10 p.m. to 3 a.m., including the supposed buy-bust operations. And number five, 18 of the slain victims' family members, relatives, neighbors, or friends were taken into custody and or detained and subsequently charged. By virtue of the undisputed participation of the police in many of these killings, there is an obligation on the part of the policemen involved and their superiors to submit themselves to inquest or preliminary investigation proceedings before the prosecutors. This is pursuant to the PNP operational procedures. Moreover, Your Honor, the prosecutors have the duty to conduct inquest or preliminary investigation pursuant to DOJ Circular 61. But in all the 23 deaths in the hands of policemen in San Andres Bukid, there was not a single death incident that was submitted to the prosecutor for investigation. Judging by the fact that not a single one of the relatives or witnesses of the victims has been invited to any kind and form of investigation. The fact that the police do not submit themselves to investigation by prosecutors betrays a frame of mind that the policemen consider themselves to be the sole, the final, and unassailable judges of the legality of the killings that they perpetrate. They virtually consider themselves to be immune from judicial inquiry into the legality of their killings. They consider themselves to be above the law. This is out and out impunity, Your Honors. And why would the police not consider themselves to be above the law? The highest officials of our country have publicly and repeatedly encouraged policemen to do more killings, and they have even assured them of protection and even pardon. President Rodrigo Duterte has made the following statements on various occasions. Number one, quote, Hitler massacred 3 million Jews. Now there are 3 million drug addicts. I'd be happy to slaughter them, unquote. Number two, he also declared that fish in the Manila Bay would be fattened by eating the bodies of drug suspects killed. Number three, he said that he will provide a, quote, pre-signed form, unquote, to law enforcers, which assures the latter of a presidential pardon should they get prison terms for deaths during encounters with criminals. Number 4, he also suggested that police plant evidence and guns in crime scenes to make it appear as though they fought back. Number 5, he told policemen, quote, "I will be there to protect you, do your duty, and if in the process you killed 1,000 persons because you were doing your duty, I will protect you," unquote. On the other hand, the Philippine National Police, through its spokesperson, declared that there is not a single case of extrajudicial killing in the Philippines. This is a complete absolution of any wrongdoing by policemen on the killings that they have perpetrated. Justice Secretary Vitaliano Aguirre declared that drug addicts and drug pushers are not humans. They are not part of humanity, and therefore killing them does not amount to, quote, "crime against humanity," unquote. House Speaker Pantaleon Alvarez also stated that he personally has no problem with vigilante killings and that he would prefer a shoot-to-kill order on criminals. Even Solicitor General Jose Calida was reported by the media as stating that the killings that were happening were not enough and that he was urging the police to kill more. These public statements of high government officials of our country serve to encourage, bolster, and support the practice, behavior, and threat of impunity by our policemen. And this is notwithstanding the very own admission of President Duterte that the police force is, quote, "corrupt to the core," unquote. In addition to the encouragement by top government officials for the police to commit impunity, the police are emboldened to commit impunity because they feel they are supported by a specific command circular issued by their superior. Your Honors, our petition only seeks protection for our clients because we are bound by the wishes of our clients. Because of constant fear, all they seek is protection for their families. They are afraid to frontally confront the government. But we are raising the fact that it is the CMC which emboldens the police to violate the rights to life, liberty, and security of the petitioners. It is the CMC that fosters acts of impunity, whether in the guise of tokhang, buy-bust, hot pursuit, service of warrant, and all kinds of police operations. It is because of the CMC that policemen feel invincible when they trample upon the constitutional rights of our people. As an officer of the court, and because of the issues mandated by the Supreme Court in its advisory, I am not forbidden from sharing my personal position on the constitutionality of the subject CMC. I earnestly believe that Operation Tokhang is illegal, both on its face in the subject CMC and in its adopted practice of implementation. The conduct of Tokhang as directed in the CMC violates Article 3 of the Constitution, particularly the rights of persons under investigation, the rights of the accused, the rights against unreasonable searches and seizures, and the rights to life, liberty, and security, among others. When policemen conduct the third stage of Operation Tokhang, which is the house-to-house visitation, the person visited is legally under custodial investigation pursuant to the definition laid down by this court in People v. Tan, 1998, and also pursuant to the definition made in Republic Act 7438. The rights of persons under investigation under Section 12 of Article 3 of the Constitution kicks in, and this is not observed in the subject CMC. The right of a citizen against unreasonable searches and seizures also kicks in, and this is not observed by the subject CMC because the person who is visited has no choice but to allow police entry in his house. Otherwise, there are consequences if he refuses to do so. The subject CMC contains a provision that negates consent. The CMC states that, quote, "any person suspected to be involved in illegal drug trafficking who denies or refuses the house-to-house visitation shall be referred to the anti-illegal drug units for immediate case build-up and negation." The processing and documentation stage also violates the rights of the accused by not complying with the rules on custodial investigation and the rights of the accused. Moreover, when a person, quote-unquote, voluntarily surrenders under Operation Tokhang, his rights to custodial investigation and his rights as an accused are not observed. He is even required to become an informant as a condition for the acceptance of his surrender. Your Honors, The brazen disregard for the Bill of Rights in the CMC reveals that hidden behind the war on drugs is another war that is being waged by the government. This hidden war is the war against the Bill of Rights. It is a war to dilute, to render sterile, or even to completely render irrelevant the Bill of Rights in open the floodgates for the issuance by the PNP of a variety of CMCs. Nothing can prevent the PNP thereafter to issue a CMC to wage war against corruption, a CMC to wage war against gambling, and a CMC to wage war against suspected communists and activists. In all these subsequent wars, the police can do all the things that are now lamentably happening in the current war on drugs. Your Honors, our rights to life, liberty, and security, as well as all our constitutional rights that ensure protection against an abusive government, are hard-won rights in all the wars and struggles that we as a people have waged in our revolution against Spain, in our war against the US and Japan, in our struggle against the Marcos dictatorship. So much for us. May the members of this honorable court remember the lives sacrificed by our ancestors and our heroes for us to enjoy these fundamental rights. Your Honors, this case is correctly a class suit petition, and there is one incident that perfectly illustrates this fact. When the double killing of Jerry Estrelier and Randy Concordia happened in San Andres Bukid, the killing terrorized the whole street or alley where they lived. The residents in that street feared for their lives, and they didn't feel secure in their houses because they feared that the police could also enter their houses anytime, and that they could be the next victims of an extrajudicial killing. For 2 months, Your Honors, the residents in that street abandoned their homes at night and slept in the nearby market. They spent Christmas, New Year, and Valentine's Day sleeping in the market. When it rained, they slept inside the parked jeepneys along the street. This is an example of the fact that when a killing happens, it does not only violate the right to life of the victim, it violates the right to security of everyone in the community. Besides, Your Honors, the subject CMC affects all the citizens of this country because it is nationwide in scope. The rights to life, liberty, and security of 100 million Filipinos are affected by this memorandum circular. Every single resident of San Andres Bukid is affected by this CMC, and they certainly have the right to pray for a community or collective writ of Amparo. In closing, Your Honor, allow me to quote from People versus Chua, which was decided by this honorable court in 2003. The government's drive against illegal drugs needs the support of every citizen, but it should not undermine the fundamental rights of every citizen as enshrined in the Constitution. The constitutional guarantees against warrantless arrest and unreasonable searches and seizures cannot be so carelessly disregarded as overzealous police officers are sometimes wont to do. Fealty to the Constitution and the rights it guarantees should be paramount in their minds. Otherwise, their good intentions will remain as such simply because they have blundered. The criminal goes free if he must, but it is the law that sets him free. Nothing can destroy a government more quickly than its failure to observe its own laws, or worse, its disregard of the charter of its own existence. Thank you, Your Honor.
Thank you, Attorney Butuyan. May we request Justice first? May I request
except CMC 16-2016 that uses those terms, Your Honor, and uses it in the manner and in the number that they are used in that circular.
Okay, PNP, revised PNP Manual of Anti-Illegal Drugs Operations and Investigation issued in February of 2014 uses the terms neutralize, neutralization, and negation. You check that out because
Yes,
it's repeatedly used in that manual, and that manual was issued in February of 2014 during the last administration when the head of the DILG was Secretary Marojas.
If I may, Your Honor, I did some research into the use of that term. Apparently, neutralization is a term that has been used both here and in the United States and in other countries to refer to several different things. In some contexts, it means to kill. In other contexts, it means to repel. But our argument in this particular case, Your Honor, is how do the police understand that term? Considering the fact that the PNP chief himself uses the term to mean kill, and that in at least one PNP report, they replaced the word killed with the word neutralized, then we believe that the circular could easily be construed by any police officer to mean the word kill because of the term neutralization.
Okay, on August 9, 2016, the PNP Director General De La Rosa was quoted in a Davao paper, Davao Today, and he said that their target is for all drug personalities in the area to be, and I quote, neutralized, meaning they should surrender, be arrested, or killed during drug operation, end of quote. So this was August of 2016, at the start of the drug campaign,
Yes, Your
drug
Honor.
war. And that was his understanding of the word neutralize, arrested, surrendered, or killed in a drug operation. So would you agree that that is the understanding of the PNP?
Yes, Your Honor.
And in several of their reports, even in the 2016 annual report of the PNP, they used the term neutralized to include arrested, surrendered, or killed in operation.
Yes, Your Honor.
Okay, so it's not, doesn't mean only killed. It's a general term, and it has been used even during the previous administration. Also, the word negation has been used in the PNP manual of 2014. Now, when the current CMC 16-2016 states that these drug targets will be neutralized, what could be the meaning of that, taking into account the understanding of the PNP Director General?
It would refer, Your Honor, to one of three things: being surrendered, being arrested, or being killed.
Yeah, it could mean either of the three.
Yes, Your
Either
Honor.
you arrest them, or you make them surrender, or you kill them in a drug operation. That's the meaning.
Yes, Your Honor.
But their defense is that it is a legitimate drug operation. But that is their defense, correct?
Yes, we take issue with the use of those terms repeatedly in the circular because they could easily be construed, Your Honor, considering the pronouncements of the PNP chief himself, to include authority to kill. And if the circular, if the chief of the PNP simply meant to arrest and prosecute, then he should have used those terms and should not use terms that are subject to easy misinterpretation by the policeman on the ground.
Okay, let's go to another. The CMC Circular 16-2016 also states that in Operation Tokhang, if the household people deny or refuse entry, they will be subject to a case build-up and negation. What is the meaning of case build-up?
Well, if it's only case build-up, Your Honor, that to me means evidence, gathering of evidence against that person. And I would have no problem if the circular ended with case build-up. What we question is why they had to add the term negation when that term has no counterpart in law, and that term now invites the police officer on the ground to interpret it the way he would understand it, Your Honor.
Okay, when is the police justified in making a case build-up?
When any illegal activity is brought to their attention, Your Honor, then they are supposed to gather evidence, bring it to the prosecution.
When there
if
is a
they have
suspect.
enough. Yes, Your Honor.
Now, when they go to the house under Operation Tokhang, they knock on the door and the household people refuse to allow them to enter. Is that sufficient ground to consider the household people suspects? That they will now be subject to a case build-up?
I don't believe so, Your Honor, because it is the right of every citizen to refuse an entry if there is no search warrant, and
So-
that should not be taken against the person who
What
refuses.
right is violated when the police conduct a case build-up because they were refused entry into a private home?
Well, the rights enshrined in Section 3, Article 3 of the Constitution against unreasonable search and seizure, the right to be presumed innocent until proven otherwise in court, these are among the rights that are violated when that happens.
The right to privacy. They may
Yes, Your
refuse anybody to enter their home, correct?
Yes, Your Honor.
So when the police conducts a case build-up just because they were refused entry, they violate actually the right to privacy, correct?
Yes, that is correct, Your Honor.
How about negation? What is the meaning of negation in that CMC 16-2016?
Again, Your Honor, that term is subject to various interpretations by the officer on the ground, including interpretations that could easily mean shortcuts, and that is why we question it. In that particular provision cited by Your Honor, they say if the person refuses to be visited, then he must be referred for immediate case build-up. That's fine. But when they add "and negation," that leaves a lot of unbridled discretion to the police to decide what negation means, because there's no definition in law of that term.
The word negation was used also in the 2014 manual. So it's not new. What you're saying is that it's vague. It can be interpreted in many ways.
It could be construed to allow shortcuts or even to encourage shortcuts on the part of the police, Your Honor.
Yeah, so if it could be interpreted in many ways, per se, you cannot claim that the manual or the circular is unconstitutional because of that. You have to show in the implementation, they actually violate constitutional rights.
If
You cannot declare it unconstitutional facially because it's subject to many interpretations, correct?
If it were only the use of the term negation in isolation, Your Honor, perhaps I might agree, but the repeated use of both terms, neutralization and negation, coupled with the declared understanding of the PNP chief that neutralization includes killing, that we submit is unconstitutional.
Okay, thank you, counsel. I'll ask Attorney Butuyan. Counsel, are you familiar with the EO 226 on command responsibility of the PNP? This was issued by President Ramos sometime in 1995.
I haven't read it, Your Honor, but we will discuss it in our memorandum, Your Honor.
Okay, because their PNP officials are held responsible. They're presumed to know of illegalities or irregularities or crimes committed by their subordinates under certain circumstances. Can you discuss that in your...
We will, Your Honor. Thank you, Your Honor.
Okay, you are of course familiar with the Republic Act 9851 on the responsibility of a superior. That's the act on crimes against international humanitarian law that we legislated into a domestic law. Now, there is a provision there on responsibility of superiors for acts committed by their subordinates. In other words, superiors, even if they are not directly involved, will be liable for illegal acts of their subordinates if they could have known or they could have, by the exercise of diligence, supervised them properly. Now, you discuss that also.
We will, Your Honor. Thank you, Your Honor.
Because if you can show that there were really illegal acts during the operations, and this is widespread all over the country, correct?
Yes, Your Honor.
Now, how many people have been killed in Operation Tokhang so far?
Your Honor, as of October 2017, the official figures of the PNP is 3,800, Your Honor. But private groups, they number it at, they total it at more than 13,000, Your Honor.
3,800 are those who were killed in legitimate drug operations, according to the
Quote-unquote
police.
legitimate, Your Honor.
Yes, but that excludes those who were killed by vigilantes.
Yes, Your Honor.
Or deaths under investigation.
Yes, Your Honor.
So what will be the total if you add all of them?
If I remember correctly, Your Honor, in the official PNP figures, they total the number of deaths under legitimate quote-unquote police operations to 3,800, and the deaths under investigation, so-called, Your Honor, is about 2,500, Your Honor.
As of?
As of October 2017, Your Honor. That's the
Okay.
figures of the PNP, Your Honor.
Let us say, let's just take a figure of around 5,000.
Yes, Your Honor.
Or bring it down to 3,800, what was reported by the police. Is that considered widespread already? Widespread occurrences of people killed in police operations? Is that widespread?
It is widespread, considering that these killings happened in just over a year, Your Honor, compared to the martial law figures, Your Honor.
Is that, were the killings systematic?
It is systematic, Your Honor. If you go by our experience in San Andres Bukid, because there are many commonalities, Your Honor.
So you are saying the killings have been widespread and systematic.
Yes, Your Honor.
What is the consequence if the killings are widespread and systematic?
I suppose it's going to, it can be tantamount to crimes against humanity, Your Honor.
And we have adopted that under Philippine laws, correct?
Yes, Your Honor.
Under Republic Act 9851.
Yes, Your Honor. In fact, we have acceded to the ICC jurisdiction, Your Honor.
Okay, thank you, Counsel. That's all.
Thank you, Your Honor.
Justice Bernabe.
Okay, good afternoon, Council. Now, the Almora petition is captioned for writs of amparo, injunction and prohibition, temporary protection order, and temporary restraining order. Now, there are special procedural rules governing a prohibition action and an amparo proceeding. Prohibition is governed by Rule 65 of the Rules of Court, while the rule on amparo is governed by AM 0719 SC. Now, if you go over them, are the parameters found in each of these rules identical, or are they different?
They are not identical, Your Honor. There are some requirements in one rule that may not be present in the other.
So there are distinct sets of rules for each proceeding.
Yes, Your Honor. But in our petition, we, as much as possible, complied with both the requirements of both.
But you merge them in one petition.
Yes, Your Honor.
Okay, now is that proper?
The Solicitor General argues that it is a violation of Rule 2, Section 5, but we beg to disagree, if Your Honor, please. Rule 2, Section 5, in particular, Section 5B, states that joinder shall not include special civil actions or actions governed by special rules. Our interpretation of that provision is that you cannot join in one petition an ordinary civil action and a special civil action or an action governed by special rules. Our submission, if Your Honor, please, is that since in this particular case the issues and the facts are the same, there should be no hindrance to our joining both petitions in one proceeding.
Can you consider a writ of amparo as an action? Or is it a special proceeding?
It's governed by a special rule. In my understanding, Your Honor, it is really ancillary to the typical, regular rules that we follow in the rules of court.
All right. Now, in memorandum dated October 10, 2017, the President designated the PDEA as the sole agency in charge of the conduct of all campaigns and operations involving illegal drugs. Is
Yes,
that
Your Honor.
correct? Now, the PNP was merely ordered to relay, deliver, or bring to the PDEA's attention all information or data received by them. In the meantime, the PNP has been tasked to maintain police visibility. Now, does the President's subsequent issuance of this October 10, 2017 memorandum render moot the petition for a writ of prohibition against CMC 16-2016?
I believe it does not render the petition moot, if Your Honor, please. It is well settled by the decisions of this court that there are at least 4 exceptions to the
And
rule
what is
on
the
mootness.
applicable exception to
This
the mootness?
first grave violation of the Constitution, I believe that applies to this case. Second, an exceptional character of the situation in which paramount public interest is involved. I believe that is also applicable here. Third, the constitutional issue raised requires formation of controlling principles to guide the bench, the bar, and the public. I submit that applies as well. And fourth, the case is capable of repetition, yet evading review. If I may, Your Honor, the memorandum of the President can be rescinded anytime. It is not really an exercise of his ordinance power because it is not an executive order, it's not an administrative order, it's not a memorandum circular, it's not a memorandum order, it's not a proclamation, it's not a general order or a special order. It is simply entitled a memorandum.
So you're saying that the power can be reverted back to
Could
the
be
PNP
easily,
anytime?
yes, Your Honor, by the
All right.
stroke of a pen.
Now, the Almora petition essentially argues that the words negation and neutralization in CMC 16 refer to killing, and you said that the legal basis for that argument is the understanding of the people as an arrest, surrender, or get killed. And of course, you are saying also that it is the actual implementation of that order and the public statements made by the officials of the administration. Now, how do you reconcile these public statements with the coordinating instructions of CMC 16, wherein it is explicitly stated in item 8.E, please go over it, that all operations shall conform with the provisions of RA 9165, the rules of court, and strictly observe the rights of the accused enshrined in the Bill of Rights under the Philippine Constitution, other allied laws, rules and regulations, as well as the internationally accepted principles of international laws, public policy, and with due observance of human rights?
It is true, Your Honor, that that provision is there, but it is our submission that that simply pays lip service to these constitutional principles because the operative words that are found repeatedly throughout the circular are the words neutralization and negation.
So you are saying that these statements are there, but they are not being followed?
They're just simply, they were there, Your Honor, to pay lip service to these requirements, but they're not intended to provide limitations to the conduct of the police.
No.
And insofar, Your Honor, as the term neutralization and negation is concerned, there is a maxim of construction which states that words are to be understood in the context in which they are used. And we submit that by the words being used by the PNP chief himself and by the PNP as an organization, equating neutralizing with killing, there's no other way the police would easily be susceptible to understanding it in the same manner.
Now, both the Almora and Daño petitions seek numerous reliefs from the court in relation to their petitions for a writ of amparo. Among the provisional reliefs, the Almora petition seeks a temporary protection order prohibiting respondents or any of their agents or representatives from entering into a radius of 1 kilometer from petitioners' respective residences and places of work. Now, first of all, is this relief warranted under the rules?
Your Honor, I believe that that was the prayer of the other petition, not ours.
Okay, can I call the counsel there? All right.
Yes,
Would you
Your
want
Honor.
me to repeat the question?
No, I got the question,
Or
Your Honor.
you got the
Yes,
question?
Your Honor.
All right.
Your Honor, the relief was granted in our earlier petition, which is the Murillo petition, Your Honor. When we filed it, Your Honor, the Supreme Court granted a 1 kilometer radius protection, Your Honor, for our clients, Your Honor, until the case was decided by the Court of Appeals, Your Honor.
Okay, would not this be tantamount to the court imposing a police-free zone that would also prove detrimental to the safety and welfare of others residing within that area?
Your Honor, we are not against all police operations. We are against police operations which violate the Constitution and violate the law, Your Honor. If the police, Your Honor, would institute procedures which are pursuant to the PNP manual, which is very detailed, Your Honor, as to the steps that the police are supposed to take, Your Honor. Your Honor, we have no objections, Your Honor.
All right. Now, the Almora petition also seeks the issuance of a temporary protection order prohibiting respondents or any of their agents from harassing, threatening, arresting, or physically harming petitioners and their immediate families. Now, what is the evidentiary basis for petitioners to support the issuance of this order?
We attached to our petition, Your Honor, the affidavits of the petitioners. In the affidavit of Rowena Apari, she attested that even after the killing of Rex Apari, her son, the same persons who were responsible for the killing were seen repeatedly in the vicinity. In fact, both Rowena Apari and Jefferson Soriano, the other petitioner, have left the places of where their
And you
relatives
believe-
were
And you
shot.
believe that these affidavits constitute substantial evidence?
Yes, Your Honor. In the case of Jefferson Soriano, he survived a shooting and still continuously fears for his life that he will be still the target of a killing.
Okay, can I call Attorney Butuyan again? Now, the Daño petition seeks that respondent, their officers or agents be prohibited from maintaining a drug list and the officials of all 28 barangays of San Andres Bukid from coming up or submitting a list of alleged drug pushers. Now, both reliefs are sought until respondents' full compliance with, among others, a regulatory assurance against arbitrariness, bias, and criminal machination. Now, first, is this relief founded under any provision of the Amparo rule?
It is founded on the experience of our clients in San Andres, Your Honor. Because what happens, Your Honor, is that the police, they force the barangay captains, Your Honor, to come up with names. And in our experience, some, and actually several of the victims who died already, Your Honor, are some of the names that were included in the list. And we have reports that the police threatened the barangay officials, Your Honor, if they do not come up with a regular list that they report to the police, Your Honor. So we want a system that would not make this arbitrary, Your Honor, and it would comply with rules, with laws and regulations, Your Honor.
Now, would this not constitute a breach of the domain of the intelligence gathering prerogatives of the executive department?
Well, insofar as the conduct of the police is concerned, Your Honor, it violates our laws, Your Honor. We want them only to comply pursuant to law, Your Honor.
Now, how do you propose to have the compliance for this regulatory assurance against arbitrariness, bias, and criminal machination? How do you propose that this be implemented? What is your proposal for its implementation?
If, Your Honor, if the persons who are supposed to be reported to them, Your Honor, are given the chance to submit their own evidence or to explain their side, Your Honor, so that there's going to be transparency and there's going to be due process, Your Honor, that would be an option, Your Honor.
What other options do you have?
For as long as there is compliance with due process, Your Honor, and the opportunity for the persons who are included in the list to present their side of the issue, Your Honor.
Okay. Let's go to another topic, the class suit.
Yes, Your Honor.
Okay. Now, according to jurisprudence, the necessary elements for the maintenance of a class suit are that the subject matter of the controversy be one of common or general interest to many persons,
Yes, Your Honor.
and that such persons be so numerous as to make it impracticable to bring them all to the court. Now, in the case of the Daño petition, what is the alleged subject matter of the controversy that is one of common or general interest?
Your Honor, the right to life, the right to liberty, and the right to security, Your Honor. Every time there's a killing, it affects the whole community. Your Honor, the situation in San Andres Bukid, Your Honor, it is a slum area. The houses are on top of each other. In fact, in one alley, there would be hundreds of people, Your Honor. And if there is a killing, Your Honor, there is fear in the entire community, Your Honor. It affects everyone. It affects the right to security of all the people in the community, Your Honor.
But in the case of Matay versus Consolidated Bank and Trust Company, the phrase subject matter of the action was defined as the physical facts, the things real or personal, the money, lands, chattels, and the like in relation to which the suit is prosecuted. It does not cover the delict or wrong committed against the petitioners. So how do you explain this?
Your Honor, the factual circumstances that have arisen as a result of CMC 16/2016, Your Honor. The fact that it applies nationwide, the fact that the police can proceed against anyone in any community, Your Honor, at night. Everyone's life is at stake, Your Honor. It's in danger, Your Honor. So, Your Honor, pursuant to the pronouncement of the Honorable Court in Tagitis, that the rules on amparo are evolving, Your Honor. And in fact, this Honorable Court has issued orders that are not actually found in the rules on amparo, but they have issued it anyway, like requiring the CHR, Your Honor, to do the investigation even if it's not part of the rules, Your Honor. We beseech the Honorable Court to issue similar reliefs, Your Honor, in this particular case.
Now, is a class suit appropriate in this case when the Daño petition apparently presents separate and distinct versions of facts relative to several petitioners who are each seeking the relief of the writ of amparo?
We believe so, Your Honor. In fact, we came across a jurisprudence in South America, in Argentina or Chile, Your Honor, where the High Court there granted a collective amparo for an entire community, even if only a few of the residents filed the petition, Your Honor. So we are virtually seeking for the same, Your Honor, even if there is no provision for a collective amparo. So that's why we had to resort to a class suit, which is the one that is recognized under our rules, Your Honor.
All right, may I just call on Attorney Jokno for my last question. Now, in the Almora petition, petitioners questioned the validity of the department, the DILG Memorandum Circular 2017, which requires all cities, municipalities, and barangays to establish a system of reporting suspected illegal drug personalities through hotlines, drop boxes, electronic mail, short service message. Now, in numerous decided cases, confidential informants have tipped policemen on the activities of suspected drug peddlers. Now, is there any substantial difference between the act of tipping policemen with the methods of reporting under the circular I just said?
Your Honor, even in the cases involving confidential informants, this court has struck down actions done by the police that are based on the furtive fingers of unknown informants. The case of People versus Aminuddin is one. There are a number of other cases where the court made similar pronouncements. What we are concerned with here is that the circular of the DILG is but an extension of CMC 16 in terms of making people submit names. It has been our submission that the police should just do the functions provided in the PNP manual of gathering evidence. There's all the authorities already provided in their existing issuances. And if we allow the practice of any person being anonymously reporting the names of others, it is extremely dangerous to the rights to life, liberty, and even property of our people. Anyone's names could find their way into a drop box. If I have a personal grudge against another person, if I'm in a barangay and I have a political enemy there, what is to stop me from putting his name or her name in the drop box? How will the barangays determine if that name is really valid or not? They are not law enforcement, so most likely they would then forward these names to the police. Once that gets into the hands of the police, how will they check and validate it? If it will be based on CMC 16, Your Honor, we have already discussed the dangers that that will entail.
Are these reports not subject to further verification by the police?
It's not clear, Your Honor, how these reports are going to be verified. The DILG circular simply states that it will establish a system for reporting.
Now, if a reported suspect is unlawfully placed in custody or restrained of his liberty, does this mean that the DILG circular is invalid, or is this a problem of implementation and the reliefs should be asked from the proper criminal or administrative action?
If that person was picked up or otherwise his rights were violated because his name was submitted under the DILG circular, then I believe it is the circular that is to blame, Your Honor.
All right. Thank you, Counsel.
Thank you, Your Honor.
I'll ask Justice Leonen first and Justice Hardileza. Justice Leonen.
Can I ask Attorney Diokno to take the podium? Good afternoon.
Good afternoon, Your Honor.
You have no objections to criminalizing illegal drugs. Is that not correct?
Naturally, Your Honor. We're all against illegal drugs, illegal
You are
drug
against illegal
syndicates.
drugs, and you approve of a policy to be aggressive in order to arrest people who not only use but actually peddle and perhaps manufacture or import illegal drugs. Is that not
Definitely.
correct?
Yes, Your Honor.
So your case is not actually to stop the war on illegal drugs.
No, Your Honor, it's
But
not.
would you agree with me that you are trying to convince the government through this court to adjust its program so that it does not unnecessarily alienate communities that it is supposed to protect or unnecessarily undermine some fundamental rights? Is that not
Yes,
correct?
Your Honor.
So it is wrong to say that you are asking this court to issue a writ to stop the aggressive police action against drug pushers, drug manufacturers, drug importers. Is that not correct?
Yes, Your Honor.
Okay. So, in other words, if you succeed in having Command Memorandum Circular 16-2016 and DILG Circular 112 declared as unconstitutional, would this in fact stop the government from continuing to go against drug pushers?
No, Your Honor, the government would still have all the powers under the law to go after drug pushers, drug users, and drug syndicates.
Under the law, which means, therefore, that police can continue with getting information from the community, developing that information, gathering evidence, getting warrants of arrests, and in certain instances doing warrantless arrests, as in many of the cases that have come to this court, and finally prosecution and conviction. Is
Yes,
that
Your
not
Honor.
correct? So, in other words, declaring CMC 16/2016 and DILG 112 as unconstitutional will have the effect of probably clarifying certain rights of certain individuals vis-a-vis the power of the government to go against illegal drugs. Is that not correct?
Yes, Your Honor.
Okay, just to be clear. Now, do you have a copy of CMC Circular 16/2016 with you now?
Yes, I do, Your Honor.
Can you read into the record, page 17, number 8, coordinating instructions from the Chief PNP, subparagraph E. I think it's on page 17 of the copy that you provided the court.
I'm looking at page 17, Your Honor. May I know which portion
Number
here?
8, this is coordinating instructions, subparagraph E. Can you please read to the record, subparagraph E?
Oh, yes, this is found on page 16. Coordinating instructions. A, strictly implement the protocol on the conduct of anti-illegal drug operations. B, as far as
No,
practicable...
letter E, letter E.
B or
E, as
P?
in elephant.
Oh, I'm sorry, Your Honor, letter E.
Sorry
All
for
operations...
my accent, I'm Ilocano.
Sorry, Your Honor. All operations shall conform with the provisions of RA number 9165, the rules of court, and strictly observe the rights of the accused enshrined in the Bill of Rights under the Philippine Constitution, other allied laws, rules, and regulations, as well as the internationally accepted principles of international law, public policy, and with due observance of human
Just
rights.
the text, okay? So it's clear from the text that the instructions of the Chief PNP to all its operating units is that it respects not only the rules of court, but it does mention the Bill of Rights, it mentions all other statutes, and even the international obligations that we have adhered to. Is that not correct? Just from the text.
Yes, that is true, Your Honor.
Can you proceed to look at letter G, as
Letter-
in goat?
The rules and regulations on the recruitment of personnel to and from anti-illegal drug units must be strictly implemented. That is letter G.
Yes. Okay, now, correct me if I'm wrong, but your theory is that because the CMC circular uses the ambiguous terms negate and neutralize, therefore, it can mean that the operating units are free to actually do whatever they think the President and the Chief PNP wants them to do. Is that not correct?
That is one of our arguments, Your Honor.
Except that the actual text of the CMC circular actually is very clear. They tell the police, notwithstanding what the orders are as of present, there is these operating instructions that you should respect the Bill of Rights. So does this not undermine your theory of the case?
I don't believe that it undermines our theory, Your Honor. It's to be expected that a PNP circular would pay lip service to the Constitution and even to respect for human rights. We would have no problem if...
Can I follow up on that concept of lip service? Any official issuance coming from the court, coming from the President, coming from DILG Secretary, coming from the Chief PNP, should we accord it with a presumption that they do not mean what they say? Or should we accord it a presumption that they actually mean whatever it is that is included in the text of those documents?
I'm not sure how to answer that question, Your Honor.
Is there a presumption of regularity in the performance of official function?
There is a presumption
Yes.
generally.
So whenever the Chief PNP puts in an order a command memorandum circular, which is similar to the operational directive of the Armed Forces of the Philippines, it tells its men and women, all its personnel, that these are the frameworks and guidances that they should follow in terms of their operations. Should we assume that they do not mean what they say?
Well, we should have to understand the document in its entirety. If the document, the circular, were only limited to what was found in letter E, we would have no problem.
But
What we
before we get
question,
into
Your
that,
Honor, is why...
I'm asking, where do we get the idea that E and G are only lip service, that they are not commands coming from the Chief PNP to their personnel?
From the other portions of the circular which require and command, number 1, neutralization and negation, number 2, compilation of lists, number 3, house-to-house visitations without warrant. Your Honor.
Neutralization and negation do not have definitions, correct?
No definitions
Yes.
in law,
And
Your
in
Honor.
terms of interpreting a legal text, we have to read it in the context of all the other provisions contained in that text. Is that not correct?
Well, the maxim that we are citing is that words should be understood in the context in which they are used.
Okay. The right to life, where is it found?
In the Constitution, Your Honor.
Article 3?
Article 3,
Section 1.
Section 1.
Okay, no person shall be deprived of life, liberty, or property without due process of law. Was that referred to in subparagraph E, page 17?
Generally under the term Bill of Rights, I suppose, Your Honor.
So there was a command to respect the Bill of Rights, correct?
Yes.
Yes, very clear. It is not like negation or neutralization, but it's very clear what the Bill of Rights states because it is enumerated in our Constitution. What about violation of domicile? Is there Section 2 of Article 3 of the Constitution? Is it protected in Article 3, Section 2 of the Constitution?
Well, the letter E makes
The
reference
rights of
to
the
the Bill
people
of
to be
Rights
secure in their
generally.
persons, houses, papers, and effects against unreasonable searches and seizures shall be inviolable. That's the actual text of Section 2, Article 3. Is that not correct?
Yes, Your Honor.
Was it referred to in CMC circular?
Generally, it was referred to when they used the term Bill of Rights, Your Honor.
Okay, so here is our difficulty. There is an operational directive, a command memorandum circular issued by the PNP chief, which contains, yes, the words negation, which contains the words neutralization, but at the same time makes reference to the actual text of the same Constitution that you are now using, which states that the interpretation of negation and neutralization, which means to kill, is wrong. So shouldn't we assume that all personnel should read the CMC circular the way that you are reading it now?
The operative portions of the circular, Your Honor, are where you find the terms neutralization and negation in how the war on drugs double barrel is to be implemented. Those
Maybe to put
are
it
the
in
provisions, Your
maybe
Honor,
to
that
put it
the
in another way.
police on the ground are going to implement.
Yes, maybe to put it in another way. Yes, there are killings. There may be killings. Of course, that's a question of fact. Yes, there may be lots of killings. Of course, that's a question of fact. But do we actually say that all of those killings are because of CMC Circular 16-2016? Or is it that all of these are violations of CMC Circular 2016, specifically subparagraph 8, E and G?
What we are saying, Your Honor, is that the circular can be construed by the man on the ground, by the officer on the ground, to allow killing, to allow shortcuts that are not authorized by our Constitution or by existing law.
Even though it says, always
Even though-
respect the Bill of Rights.
Yes, Your Honor. This is not the first document that was issued by the PNP which contains this kind of language, but at the same time also contains language that would abridge the Constitution.
Okay? Perhaps this can be more covered in your memoranda.
I
Okay.
will do that, Your Honor.
In your petition, you raised questions of fact. Is that not correct?
No,
That there is, or there have been an attempt on the life of Jefferson Soriano. Isn't that a question of fact?
we have included his description of what happened to him, Your Honor, but we don't raise it as an issue in this case.
But the
What we
Solicitor
are-
General takes issue. So therefore, or wants to question the circumstances under which Mr. Jefferson Soriano was actually injured. Is that not correct?
Precisely, Your Honor, that's why we are asking for an investigation into the...
By the way, is Mr. Jefferson Soriano here today?
Yes, Your Honor, he is
Can
present.
I ask him to stand up? I will not ask any questions because this is not the proper forum. Is he here?
He's here, Your Honor.
Yes. I understand that he has lost his voice as a result of the alleged incident?
Yes.
Very briefly, counsel, can you tell us what happened in his case?
What happened was that
Thank you, Mr. Jefferson.
he and his companions had been picked up days before he was shot, brought to a police station, interrogated about a certain Achay, I believe a known pusher in the area, and they were being forced to tell her this person's whereabouts. When they could not reveal the whereabouts, they were injured, eventually released the following day. A few days later, about a week later, he was outside of his home together with a companion when an armed man came out, met someone on a motorcycle, and then approached the two of them, shot his companion first, then shot him next, first here in the neck and then in the thigh. When he tried to run away, the man went after him, and he said to save himself, he put his head in the gutter because he had the feeling that the assailant would shoot him again in the head. And in fact, he was shot a second time in the throat. That's why he lost his voice.
Okay. All of those are facts.
Yes, Your Honor.
Is that not correct? And usually in a writ of amparo, when the court receives a petition which alleges these kinds of facts, as a matter of fact, for example, in GR number 229605, Cristina Gonzalez versus President Duterte, this court immediately issued a writ of amparo and remanded the case to a trial court for the determination of facts. So that is the usual course of the procedure in a writ of amparo originally filed with the Supreme Court. This is to ensure that the factual allegations can be traversed by the individuals that are named as a respondent. Because eventually, when a writ of amparo does issue, there is an actual command on, let us say, a particular SPO1 or SPO2, a station commander, to be at least a kilometer away always as against this individual, and further remedies are given. Is that not correct?
Yes, Your Honor.
Yes. Wouldn't it have been proper that this be a simple writ of amparo for Mr. Jefferson Soriano? Personally, I am so sorry about what has happened to him. I do not think that he deserves what has happened to him. But on the other hand, that there is a procedure in terms of the petition for a writ of amparo. And I think that lower courts are as competent to address the protection of individuals, or they should be. So wouldn't you think that the proper remedy here should have been a petition for a writ of amparo simply, so that they immediately get the succor that they actually need?
May I clarify, Your Honor? In this writ of amparo that we filed, we are not asking the court, this court or any other court, to hold anyone, to identify and hold anyone accountable for the killing. At this point, all we're asking is that the government conduct a genuine investigation into the incident, because so far none has been conducted.
Your claim is that there is no genuine investigation that is ongoing with respect to this case?
Yes, Your Honor.
Counsel, can you imagine the number of crimes that have happened throughout our entire country at any given time? Or maybe I should put it this way. Are we certain that all crimes that have happened, especially those that are brought to a police precinct and blotted, for example, somebody that has been snatched of a purse or snatched of a cell phone, they report to the police. But on the one hand, the police do not have all the resources in order to do that particular kind of investigation. So are you asking this court to single out one particular case or several particular cases and address it to the executive and tell the executive, this is how you will prioritize the crimes that have been committed? Is that what you're asking this court to do?
No, Your Honor. What we are asking for the court is to provide proper guidance to the police in terms of how these entire operations under CMC 16-2016 are being conducted.
What do you mean proper guidance to the executive? You mean that we are to tell the executive, first you deal with murders, because these are simple murders or frustrated murders, okay? Second, you deal with rapes, any kind of rape. Third, you deal with incest rapes, that kind of prioritization.
No, Your
Because
Honor.
the danger with this kind of a petition is that we might be unduly interfering with the executive's prerogative as to how to implement the law, that is the problem of the executive. And that is the reason why the president is elected. Because the people will tell him during elections, based on his platform, here is my priority, and if the people elect him, then he can assume that the people are saying, first this, then that, then after that, this, and then that again. But in this particular case, why is it now the duty of the court to tell the executive that this should be investigated?
We cite, Your Honor, please, at least two cases that this court has decided. One is the case of Morales versus Enrile, which only involved one or two individuals, and yet in that case, the Supreme Court, this court said, from now on, in all police investigations, the police must provide Miranda warnings, despite the fact that in that case, only one or two individuals were involved. We cite the case of People versus Nicandro, where in that case, again, the Supreme Court laid down guidelines for the conduct of police investigation and said, from now on, the stereotype type of advice that happened in this case should not be done in all cases of custodial
So
confessions.
what is it that you want this court to rule now? Police cannot kill suspects without provocation.
Your Honor, what we are asking the court is that in cases of nanlaban, where supposedly the persons resisted arrest, that there be a proper investigation, the firearms be secured so that they cannot be recycled, that these
Isn't there
cases
a
be
circular?
genuinely be investigated.
Isn't there now a circular, which was cited by the other petitioner, involving what to do in cases where there is death in a crime scene?
That is, I believe Your Honor is referring to Rule 15.4 of the revised operational procedures,
Yes, so-
which requires that when a dead body is found, that the inquest be done at the crime scene before the body is removed.
Okay, so
But
there is
from
now...
our understanding, that circular is not being followed, Your Honor.
So there is a circular. There is this Bill of Rights. There is the CMC command, which actually says police follow the Bill of Rights, among others. So all of these norms are already present. Okay. If the police are not doing it, then they are violating the law, correct?
Yes,
And
sir.
if they are violating the law, then the proper legal case should be filed. For example, administrative cases against the police, getting a writ of amparo from the regional trial courts. I understand that there can be thousands and thousands of killings, but I am trying to imagine the kind of writ that you want this court to issue. We can say extrajudicial killings, summary killings are illegal and unconstitutional, but that's already in the Constitution. Isn't that correct? That when somebody is killed in the crime scene as a result of a claim that there was self-defense, that there is already a procedure in the manual for the law enforcers that this should happen, that there should be forensic evidence, that there should be surrender of firearms, and so on and so forth. So what we may be dealing here is policemen not following what the rules are. Is that not correct?
Yes, Your Honor.
So what is it that you want us to do, considering all of this?
What we are asking is the same type of relief that this court granted in the cases of Balao, in the cases of Burgos, and other cases, where the court directed the law enforcement to continue and to conduct with extraordinary diligence the investigations into the incidents
So I am
involved.
imagining that the value of the decision will copy the rules and the operational manual already existing. Would that give it more teeth? Would that give it more legitimacy? As a matter of fact, wouldn't we want the police and the DILG to enforce their own rules and not rely on a court order to be able to enforce it?
Ideally, that would be true, Your Honor.
Anyway, I hope you get what I mean.
I will
in terms
cover
of
that in my
of
memorandum.
that point, okay. Counsel, when is their custodial investigation?
The minute the suspect is not free to leave,
Okay, when the police do tokhang, in accordance with the CMC circular, when they actually choose a house to, so I understand tokhang comes from conjugation of two Visayan words. One is, I don't know what tok is, but to knock.
Knock,
The
I
other
believe.
one is hangyo, which is to plead. Okay. When they choose a house, do they choose a house at random, or based on the CMC circular, have they identified a person who is a suspect?
Supposedly, if you read the words of the circular, they are only allowed to visit, according to the circular, the houses of quote-unquote suspected illegal drug personalities.
Okay, so therefore, it is not at the stage prior to custodial investigation, but would you agree with me that after they choose a house and knock on the door of that house and look for a suspect, that already is not an arrest, but custodial investigation?
Yes, Your Honor.
Do we have a law on custodial investigations?
It's RA 7438, Your Honor.
Yes. Does it require the presence of counsel?
Yes, during
Yes.
custodial
Is
investigation.
there in the CMC circular the requirement that there is counsel when the police do tokhang?
Not at all, Your Honor.
As a matter of fact, if the suspect does not open the door, what happens to the suspect?
According to the circular, he is to be subjected to immediate negation.
Actually, two options, right? One is case build-up, and the second is, of course, it uses the word and negation. So therefore, there is a threat. If you do not open the door, something will happen to you. Is that not correct?
Yes, Your Honor.
Yes. At that stage, when the person is already under custodial investigation, is that not correct?
Yes, Your Honor.
Therefore, can you consider it as a violation of Republic Act 7945?
I believe so, Your Honor.
Yes, and 7945, can you remind us, counsel, what is that law? That is the anti-torture law.
Yes, Your Honor.
Correct? That when somebody is under a coercive process, to make that person actually do something, as in this case, open the door to the police, let them in or whatever, or allow them to speak, then therefore, under a pain of coercion, then that in fact is torture according to the law. Is that not correct?
That would be, Your Honor.
Yes. So, in other words, is it possible that there is a violation of the Constitution immediately because of how the tokhang is imagined in CMC Circular 2016?
That is our submission.
And
Your
that it is a violation of the right against self-incrimination and the right to custodial interrogation.
Honor. Yes, Your Honor.
Okay, now, do they need search warrants? Do police need search warrants to knock on one's door?
I looked at the term used in the circular, Your Honor. The term is visitation. If
Generally, is there a requirement that police need a search warrant to knock on the door of any citizen?
Well, to conduct a search of a house, a search warrant is required.
To knock on the door?
To knock on the door, it may not be.
Yes.
But it depends
Is
on...
it the right of the occupant of the house, whether it is the owner or a lessee or simply somebody living there, not to open the door?
Yes.
Yes. And in cases where the person is not to open the door, can the police actually barge in?
No, they cannot.
They cannot barge in constitutionally because that's
They
precisely the protection of one's domicile, the right
Yes,
of the
Your Honor.
people to be secure in their person's houses, papers and effects, correct?
Yes,
Is
Your
there a violation of that principle in CMC Circular 16/2016?
There is, because it provides that when a person refuses, that he will be subjected to what they call case build-up and negation. In other words, the exercise of a right carries with it what appears to be a penalty.
In your cases, Almora, where was he killed?
Inside his house, Your Honor.
Inside his house, which means therefore that there was entry into his house?
Yes, Your Honor.
That's your allegation, of course,
Yes,
and
Your
that
Honor.
depends on the evidence. What about your other, Mr.
Apari,
Apari?
same thing, Your Honor.
Okay.
His house was entered.
And Mr. Jefferson Soriano?
That took place outside the residence.
He was outside. For the first two, were there search warrants that were issued?
No search warrants, Your Honor.
Was there proof that they were actually in flight? In other words, in flagrante delicto, and being chased by the police into their home?
Well, according to the police in the Almora case, there was an alleged buy-bus operation that occurred right there in the residence, and that's why the killing took place there.
Okay. Let's go to the actual procedure that you filed. So yours is a very strange petition because you filed both a certiorari prohibition case joined with a petition for a writ of amparo. Am I correct?
A prohibition with amparo, Your Honor.
A
no
prohibition
certiorari.
with amparo. Okay. Again, of course, you did mention that there is Rule 2, Section 5. Okay. And by the way, is a writ of amparo a special civil action or a special proceeding?
It's governed by a special rule. I'm not sure it would either.
It is a special proceeding because it looks at the actual status of the person. It's like a petition for habeas corpus. Is that not correct?
Perhaps it is akin to that, Your Honor.
Yes. A petition for habeas corpus looks at the situation of illegal detention. That's a status or a fact. And because of that, there is a relief that is provided. In writs of amparo, there is an immediate threat or an actual violation of one's rights to liberty, life, and security. And therefore, it's a special proceeding. Is there a prohibition in the rule for joining a special civil action with a special proceeding?
I'm not aware of any.
So under
such
your theory, you
prohibition.
said that under Rule 2, Section 5, it only prohibits an ordinary civil action, not special civil action, to be joined with another special civil action. Is that not correct?
That is my understanding, Your Honor.
And in your case, if I read it correctly, am I correct in interpreting it as that you are asking the court to issue a writ of amparo to protect the rights of your clients and those similarly situated because there is no circular, there is no legal order that is valid, that has allowed the police to do what they did in your cases?
Yes, Your Honor.
And there's no valid circular or order because they legally do not exist. Although there is CMC Circular 2016-16, which is unconstitutional and therefore legally they do not exist and therefore there is none. Is
Yes,
that
Your
not
Honor.
correct?
Yes, Your Honor.
Yes. But proceeding further, I am curious about one of your other arguments, that CMC Circular, the Command Memorandum Circular of the PNP Chief is invalid because there is nothing in writing from the President which authorizes him, the PNP Chief, to issue that kind of an order. Can you elaborate on that argument?
Under the Executive Order 292, it provides that the President shall exercise his ordinance power by issuing any of the following: an executive order, admin order, memorandum circular, memorandum order, proclamation, general order, or special order. In this particular case, if you look at the first page of the circular of the PNP 16-2016, it does not make reference to any written instructions from the President. Instead, at number 1, it says, the verbal pronouncement of the President to get rid of illegal drugs within 6 months. Considering, Your Honor, that the PNP 16-2016 radically alters the mandate of the police, considering that it intrudes and violates several sections of the Bill of Rights, it is our submission that the PNP cannot do that, and especially they cannot do that unless there is any instruction from the President.
Okay. Thank you, Counsel. Can I ask Attorney Butuyan to
Thank you,
take the
Your Honor.
podium? Attorney Butuyan, who are you representing? Are you representing the 39 with affidavits?
Yes, Your Honor.
Are you representing San Andres Bukid?
Yes, Your Honor.
Because you filed a class suit, is that not correct?
Yes, Your Honor.
But there are local government officials, in fact, all of them, all the punong barangays have repudiated your action.
Yes, Your Honor.
So therefore, do you still claim representation of all the residents of San Andres Bukid?
Yes, Your Honor. We know the circumstances behind the issuance by the barangay captains of the statement that they made, Your Honor. It was under coercion from the police forces, Your Honor.
That's a very serious allegation against the Solicitor General and those from whom they got the manifestations. Are you prepared to back this up?
Yes, Your Honor. Because, in fact, our lawyers were invited by the barangay captains, Your Honor. They were confronted by the barangay captains, Your Honor, in one forum, Your Honor. So we have personal knowledge of that fact, Your Honor.
I will not proceed to that, but I hope that you are able to back it up in your memoranda because these are very serious charges.
Yes, Your Honor.
As against the oaths of office of many of the lawyers that were involved in getting all these manifestations.
Yes, Your Honor.
Yes. You allege in your pleading that there is systematic violence.
Yes, Your Honor.
Is this systematic violence in the entire country, or is it only in San Andres Bukid?
Per the sworn statements of our clients, Your Honor, they have personal knowledge of the systematic violence in their community, Your Honor.
Wait, personal knowledge, or are all of this hearsay?
Personal knowledge, Your Honor. Insofar as,
They actually saw the killing.
well, the families involved and the relatives involved, they actually saw the killing, Your Honor. But the other parties, Your Honor, they are actually aggrieved parties because they as
All
residents,
those
Your
that
Honor.
submitted your affidavits, how many actually saw the actual killing? I have no doubt about the sincerity and the integrity of the religious of the Good Shepherd. In a past lifetime, when I went up the mountains of Agusan and Surigao helping indigenous peoples, I have encountered a lot of the sisters of this order. And I have no reason to doubt what they say is what they believe to be true. But this is a judicial proceeding. You understand, Counsel?
Yes, Your Honor. Your Honor, the religious personalities in this case wear two hats in filing this case. They are first and foremost aggrieved parties because their right to security is violated because they themselves are residents of the communities, Your Honor. Whenever there is a killing, Your Honor, their right to security is threatened, Your Honor.
You mean to say, Counsel, before 2016, no deaths occurred in San Andres Bukid?
Well, not this systematic and frequent, Your Honor, and not in the way that the
By
killings are
systematic,
happening now.
what do you mean? In other words, there could have been violence. This is a blighted community. As you have described in your pleading, and I have been also in these areas, it's really very compact. And there are all sorts of people here, and the poverty of these people drive them to, the poverty of our people, in fact, drive many of our people to do very dangerous things to themselves, to their families, and to their neighbors. That is true. So I know for a fact that there can be lots of violence happening here, lots of harassments, etc. But it is also a good community in many ways, which people do not really understand from the outside. But inside, of course, you will see the feelings of family and community that are there. So prior to 2016, I am sure that there were deaths that have happened in that area. Is that not correct?
I have no personal knowledge, but I am sure there were deaths, Your Honor.
If you had no personal knowledge prior to 2016, why do you say now that there is systemic violence?
Your
What are
Honor,
the badges of systemic violence?
Your Honor,
from
the
your
fact
perspective?
that in so many instances, the police would guard the perimeter areas while civilian armed men, Your Honor, enter houses, Your Honor. And police would use flashlights, Your Honor, to drive away persons who are witnessing, who are trying to witness the proceedings that are happening involving armed civilians, Your Honor. And the fact that buy-bust operations are being done in the wee hours of the morning, unlike before, Your Honor, when buy-bust operations normally would be done in daylight, Your Honor.
So let me clarify. You are saying that the killings are done by people in civilian clothes with the assistance of police that guard the perimeters. They enter households. They do these activities within a certain range
Yes,
of
Your Honor.
time at about, you say in your pleading, 10 to somewhere
3
early in the
a.m.,
morning,
3 a.m., Your Honor.
3 in the morning, that immediately thereafter, police come and take the body and they bring them to an authorized funeral parlor.
Yes.
Is that not correct?
Yes, Your Honor, but even before the killing, Your Honor, the police are already guarding the perimeter, Your Honor.
Okay.
Yep.
So you are actually saying that all of this, this is a sort of a modus operandi that is happening
Yes, Your
in
Honor.
San Andres Bukid.
Yes, Your Honor.
Yes. And because of that, you want this court to issue a protective order for the entire community.
Yes, Your Honor.
Against what?
Against these, well, generally,
Let me go through it very carefully. That the police will no longer enter San Andres Bukid. Do you want us to issue that order?
in the meantime that they are operating under CMC 2016, Your Honor. We want, Your Honor, that the police conduct their operations pursuant to the PNP Manual of Operations, Your Honor, which is very detailed, actually, Your Honor, in observing all the appropriate laws that would protect the constitutional rights of every citizen, Your Honor.
So you want us to issue an order to tell the police to follow their operating guidelines other than CMC Circular 2016-16?
Yes, Your
That's
Honor.
all.
And in the meantime, Your Honor, that, well, we are invoking the dual nature of Amparo, Your Honor, which is curative and preventive, Your Honor.
Well, what if this court refers all of your cases to a regional trial court or regional trial courts for them to determine the factual antecedents of all of this, and for each regional trial court to attend to each and every case, because each and every case have their own peculiarities, and the kinds of protective orders are characteristic or peculiar to those particular cases?
Your Honor, we're not actually only complaining against the killings. We're complaining against the violation of the right to security that is being done by the policemen for their operations that can happen even after these killings, Your Honor. That we're invoking the preventive nature of Amparo, Your Honor, for the court to break the expectation of impunity on the part of policemen, Your Honor, that they cannot do what they've been doing all along, Your Honor.
Yeah, the expectations of impunity come about when there are no people that come out in order to charge the police and go through the requisite rule of law. And if there is no conviction, and if there is an acquittal after there is clear evidence that comes out, is that not correct? That's
Yes.
where there is impunity, right? But when this court issues a writ of amparo to all of your clients and remands the case to regional trial courts, not one, but because you have 35, then to 35 regional trial courts, or perhaps 5 or 6 or 7 regional trial courts to attend to each and every case, then therefore when the regional trial courts act to protect each one of them, that in fact will be a deterrent for certain rogue policemen, if ever there are any, or to policemen in general, from doing exactly the same things as they have done. Is that not correct?
But, Your Honor, the 35 would refer only to the killings that have already happened, Your Honor. But with respect to future operations of the police, Your Honor.
You want us to order the executive to investigate each and every killing that has happened in San Andres Bukid.
Well, that the PNP manual be followed, Your Honor, that the police submit all the evidence, evidence with respect to these particular killings that have happened to the prosecutors, Your
My
Honor.
difficulty is this, counsel. We are the Supreme Court. We are not the Justice League. That we have superpowers. None of us have superpowers. As you see, all of us sitting here, there is no Aquaman, there is no Wonder Woman, etc. Okay. The Supreme Court's power is limited to proclamations and to doable proclamations. Now, you are asking us to tell the police to do their jobs, correct? And what would that kind of order do in terms of addressing the systematic violence that you have mentioned?
Your Honor, we humbly submit, Your Honor, that the role of the Supreme Court is not only to, or the courts in general, is not only to passively address crimes that are committed, Your Honor, but to prevent crimes from being committed, which is actually the nature of the amparo, Your Honor.
So you are wanting this court to take an additional step to declare an interpretation of our fundamental rights in the light of what may be, according to you, happening now in our country. Is that not correct?
Well, pursuant to the curative nature of amparo, Your Honor.
Okay. Can a writ of amparo ever be moot and academic? Can a petition for writ of amparo ever become moot and academic because the policy that had caused the amparo in the first place is now withdrawn? Maybe you can answer that.
I will answer that in the memorandum, Your Honor.
In the memorandum,
Yes, Your
because isn't it that a petition for a writ of amparo is asking for actual present protection because of certain factual incidents that have happened? Is that not correct?
Yes, Your Honor.
And the rule on being moot and academic refers to facial interpretation of certain kinds of laws or circulars, correct?
Yes, Your Honor.
It does not look into the reliefs that can be granted to the people that are asking for that kind of a relief. Is that not correct?
Yes, Your Honor.
Yes. Thank you, counsel. I have no further questions.
Justice Bersamin.
Thank you, Chief. May I have Attorney Jokno, please?
Good afternoon, Your Honor.
Yes, good afternoon. Attorney Jokno, I remember very well that yours was the first case, the Manalo case, that came up before the Supreme Court, and it was in that case that the Supreme Court rendered a decision or promulgated a decision on the application of the very new rule on Amparo.
And Your
So-
Honor was the presiding
Yes,
member of the
I was in the Court of
at the
Appeals.
time. Yes.
But since then, many things have happened, many decisions have been rendered, but the rules have generally been unchanged.
Yes, Your Honor.
Now, I would like to know from you if you were the one who combined Amparo with prohibition?
In our petition, yes, Your Honor.
And your objective was obviously to make your reliefs more effective.
To avoid multiplicity of suits, we wanted
Multiplicity
to
of suits.
include them in one petition, Your Honor.
You did not hesitate to do that because you believe that the rule on Amparo should be made really effective.
Yes, Your Honor.
And if that rule did not provide for any positive or affirmative act that may be done by the court in order to hasten the reliefs that you wanted, you would go in a new route and try to have another relief through prohibition.
Well, we felt, Your Honor, that the relief, that our clients needed both relief, that the circular being invalid and ultra vires can be the subject of a writ of prohibition, and that because of the danger to the petitioners, the relief sought under the Amparo could also be issued by the court.
Well, as of this moment, personally, I don't see anything objectionable in what you did because the rule on Amparo expressly authorizes the court, the Amparo court, to give you any kind of appropriate relief that would be warranted under the premises. Was that the thing that operated in your mind when you decided to do this?
Yes, Your Honor.
I'm leading you.
Thank you, Your Honor.
Okay, anyway, I don't see any strong obstacles or insurmountable hindrances that would prevent a joinder of Amparo to any kind of relief. The only limitation that the Supreme Court imposed in the rule on Amparo, as far as I remember, is that once a criminal action has been commenced, in order to prosecute a criminal or unlawful act or omission that is subject to the rule on Amparo, that proceeding on Amparo should stop or should be consolidated with the criminal action.
That is correct.
You remember that
Yes,
rule?
sir.
Now, so far, as of today, has there been any, to your knowledge, any kind of criminal prosecution or investigation conducted by the PNP or any other government agency into your case?
As far as we know, Your Honor, there has been no cases filed in court. No criminal prosecution.
Okay. Have you had anyone from the NBI, the PNP, or any other investigatory agency of the government certify to this, that there is no such pending criminal investigation?
We have no certification to that effect, although we could secure if necessary, Your Honor.
All right. On the part of the relatives of the victims, whether a victim of enforced disappearance or an attempt on the life of any of your clients, have they been in that position to follow up or to prod any agent of the government to do this for them?
With respect to the two petitioners, Your Honor, Rowena Apari and Jefferson Soriano, they are presently under the sanctuary of the church. They are not in any position to pursue any cases. With respect to the third petitioner, Eileen Almora, I understand she has made representations with the law enforcement agencies to conduct investigation, but apparently these investigations are not moving.
All right, we recently promulgated a decision regarding the Gadyan case, but that was a moot decision. Another one was also promulgated, the Kayanan case. Both of these are Amparo cases. No? In the Kayanan case, the court ordered the Amparo court, which was the regional trial court in Quezon City, to conduct more proceedings because we directed the implementation of certain directives to the government represented by its investigatory agencies into the disappearance of Kayanan. Now, this will not be possible here because you came directly to us and the court opted to hear you directly on your issues. Would you like the court to do that for you now, if there is no such pending criminal action yet?
We understand, Your Honor, that as of now, no writ has yet been issued by the Honorable Court. There was only a requirement for
Yes, we accepted.
Solicitor
We
General
decided to do it ourselves.
to comment. In the event that the court will issue a writ, we are open to presenting evidence before a lower court, which is the procedure set out in the rule.
Okay. We have to be sure that there is no such pending investigation leading to a criminal prosecution. As of now, you are not sure from your end of the case, you are not sure if there is such a pending criminal investigation.
As of now, we are not aware of any cases that have been filed, nor any complaints, formal complaints filed with the prosecutor's office. We do not know as well the status of any investigation being conducted by the law enforcement, Your Honor.
All right. Have any relatives of the deceased victim or the one who survived himself, was there any identification of the suspects, the usual suspects?
In the case of Jefferson Soriano, Your Honor, the one who survived, he could not identify the shooter. In the two other cases of Apari and Almora, the police reports stated that they supposedly fought back or resisted, and therefore there are names appearing there of the officers who allegedly took part and neutralized those persons.
Yes. Now, you remember our Manalo case?
Yes, Your Honor.
It was very good there that the two brothers escaped captivity. And then you assisted them and you came up with sworn statements identifying a general and his cohorts.
Yes, Your Honor.
Now, the court did not hesitate. I specifically recommended, as the hearing justice at the time, to the Supreme Court to proceed against these named gentlemen, the general and at least four cohorts who were part of the murder squad. Now,
yes, Your Honor,
that is an assurance to you that the court or this court and any other court will do its job if you give the opportunity to perform or to discharge that sworn duty to uphold life, liberty, and security. You still are confident about that assurance?
Yes, Your Honor.
You are. All right. What if today you have the means, you have the witnesses, and you file the case? Is that still possible as late as now?
If we have the evidence that we need to file the case, then that would be true, Your Honor. Yes.
Okay, this matter of sanctuary, in your the part of the petitioners that you represent, they are in sanctuary now?
Two of them are in sanctuary, Your Honor.
And they are satisfied with that?
Not exactly, Your Honor. I'm sure they would rather be in their normal lives. It's just that...
Would you like General Bato to give them sanctuary?
I don't think they
It's a
would
matter
agree
of
to that.
trust. Pero General Bato is publicly, loudly proclaiming that he would never tolerate tukhang killings. Don't you have confidence in that?
Well, we have nothing against General De La Rosa, if Your Honor is pleased. The petitioners, I believe, would have a natural reluctance to having someone from the PNP give them protection when it was by the admission of the PNP, their operatives who killed their relatives.
Okay. May I have Attorney Butuyan only for a short time? Attorney Butuyan, your client is a victim of disappearance or a victim of
Extrajudicial killings, Your Honor.
extrajudicial killing. You have heard the exchange between myself and Attorney Jokno. On your side of this issue, do you have any identification of suspects?
Yes, Your Honor.
How far have you gone towards the prosecution of these suspects who are identified?
Your Honor, we believe that the burden should not be shifted because pursuant to the PNP manual, the police themselves should be the ones forwarding the records of these incidents to the prosecutor and for the prosecutor to conduct the preliminary investigation or inquest, Your Honor. Our clients, Your Honor, they have no means. In fact, even just to meet with us, they don't have money for transportation, Your Honor.
No, it's not a matter of means. It's a matter, you are taking the cudgels for them,
Yes,
the legal cudgels. Did you ever go as far as writing a formal letter to any of those in authority who would be in that position to initiate, commence the investigation, go further, and file the case if warranted?
Your Honor, when we were consulted by the clients, we presented to them the array of options, Your Honor, including the filing of cases, criminal cases against the perpetrators, Your Honor. But they were very afraid, Your Honor. And among the options that we presented to them, they only wanted Amparo, Your Honor, because it was explained to them that it would not pinpoint criminal responsibility. They just wanted protection, Your Honor, in the meantime, Your Honor. And with all the statements coming from the highest officials of our country, Your Honor, absolving the policemen, they are not keen at this point, Your Honor, to pursue the criminal cases on the killings, Your Honor. They just want protection for their community, Your Honor.
No. My suggestion to you is why don't you do it now? You file a formal complaint in the ombudsman for murder, okay? If that is the case, for murder, you have identified these people, bring all those witnesses that you have so that this matter will be insulated from any kind of fear of manipulation or orchestration. Now, whatever you believe is meant by the President when he makes a public declaration like that, you must also believe at the back of your mind that that is not a pardon or an amnesty, nor is it going to be insulating this case, this particular case that you have from prosecution. It does not have any effect. It has only a general effect, but not in your particular case. Do you agree with that?
We undertake to talk to our clients, Your Honor.
So I encourage you to do that because I want to give immediate relief to your client. Now, Amparo here is preventive, curative, as you have been loudly stating today. I agree with you fully on that. But as it is, the rule of Amparo stops operating when there is a criminal action that is filed. Now, that is what my experience in the Manalo case told me. Anyway, just for the benefit of everybody else here, the promulgation by the Court of the Rule on Amparo did a lot to minimize the incidents of disappearances and what is this? Disappearances and
Extrajudicial killings.
EJ case.
Yes, Your Honor.
Thank you, Chief. Thank you. Thank you, Attorney Butoy.
Thank you, Your Honor.
Justice Hernandez.
Can I have Mr. Jokno, please? Good afternoon, Counsel. Counsel, it is your petition that seeks a writ of prohibition.
Yes, Your Honor.
But may I request Counsel Butuyan to please listen to the questions. I know you did not ask for a writ of prohibition, but may I request that you cover the area I will take up with Counsel Jokno. The meaning of the word neutralize, the government cites Black's legal dictionary. If you consult Merriam-Webster, in addition to render ineffective, which is in the Black dictionary, Merriam-Webster includes the words kill or terminate, so kill. You are raising that by his words, you are asserting that General Bato, when he uses the word neutralize, means to kill.
Yes, sir.
So it seems to me, at the very least, and we are preempting the decision of the court, that the word neutralize can have at least two meanings.
Yes, Your Honor.
And therefore, it is in that sense vague or capable of multiple interpretations. And your claim is that because it is capable of being interpreted as kill, in fact, it has been interpreted by the PNP, the people on the ground, to mean kill.
Yes, sir.
Now, I think some time ago, void for vagueness was mentioned. That was with you.
Not in our
But
petition.
let me take it up. The principle of void for vagueness, because you're asking the court to, in your writ for prohibition, to invalidate CMC, right?
Yes, Your Honor.
Void for vagueness, the principle is the accused in a criminal complaint needs to understand fully what he is accused of or what is being prohibited so that he can have his defense, right?
Yes, Your Honor.
Now, so here we are not, this is not technically four-square void for vagueness. And for that matter, a void for vagueness is a facial challenge for void for vagueness applies to freedom of speech, right?
Yes, Your Honor. That's the jurisprudence of the court.
But I think you have something here. You have a situation where a government circular, according to you, contains vague terms which can be interpreted to mean a license to kill or authority to kill. And you are saying, in effect, that that's illegal or unconstitutional or unauthorized or ultra-vires. But they all mean the same thing, essentially.
Yes.
Right? Again, if we go through the classical way that we litigate, there should be an actual case in controversy where actual parties litigate what did the police officer, assuming there is a police officer, who kills a suspect, what did he understand the circular to mean? Suppose the commanding officer says, we have to go out, and then neutralize. So you have a question of what did the police officer who actually shot, what did he take neutralize to mean, right?
Yes, Your Honor.
And so, but in that case, you have to wait for a case, maybe the first case that goes to court and goes all the way to this court will be in constitutional law, the as applied application of what is the meaning of neutralize. But that will take time. Now, there are two statistics given to this court today. I think 3,000 killed.
3,264.
3,000 plus killed. And it comes from the government, right?
From the PNP one-year report, Your Honor.
Yes. The other statistic is so many thousands arrested.
Yes, about 29,000
Now-
if I'm not mistaken.
We will ask you, and also Council Butuyan, and also the government, to give this court later in your memorandum the number of surrenderies. How many people have surrendered after the circular came out? I think it is in the hundreds of thousands. That is why we have rehab centers, right?
Yes, Your Honor.
So what I'm driving at is, if you don't have to wait for an actual case where we go into the mental state of the police officer who pulled the trigger on the meaning of neutralize, it seems to me accommodating the position of the government that neutralize can mean render ineffective or negate, and your meaning to kill. There are three statistics: 3,000 plus killed, 30,000, I think, surrendered during an operation, and hundreds of thousands surrendered. Now, I would like you to construct a argument that, and I'm not sure, and I will listen to how you will argue this, that there seems to be something there. If we have a principle that protects the accused, void for vagueness, is there a principle that will protect the citizens from a vague circular that can arguably result in 3,000 killings, even if arguably it can include negate, which is meaning arrest, and arguably negate or neutralize in the meaning of that results to surrender? Now, I know those are statistics, but I think Council Butuyan was saying that the difference between these statistics and maybe the martial law killings is all these figures come from the government. So it is troubling to have more than 3,000 killings. And with respect to your plea for a TRO, especially in the writ of prohibition, I would like the two of you to, as I said, help out this court. Is there something there? Is there a void for vagueness argument, not in the classical terms I have described to you, because I think essentially that is what you are asking for. And what bothers this court is our classical rules is that technically in a criminal prosecution you have to wait for a conviction, you raise void for vagueness in the conviction, or in the First Amendment, in the freedom of speech context, it is the only time you can use void for vagueness in a facial challenge. But what bothers me is more than freedom of speech, this is lives. And more than the conviction of somebody with a law, this is again about lives. So may I ask also Council Butuyan to cover that? Thank you, Mr. Jokno. I have some questions for Council Butuyan.
Your Honor,
No, in the interest of time, I would just like you to address
yes, Your Honor.
the same question, so I don't repeat it.
Yes, Your Honor.
But I have a different set, a few questions for you.
Okay.
It has to do with lists. The government is saying, what's wrong with lists? And they seem to have a point. Now, I'll give you a hypothetical. The ILD tells everybody, come up with lists. There is pressure to come up with a list. In one barangay, A has 50 enemies. So 50 people put him on the list. He's on top of the list. He's number one on the list. Up to that point, it seems to me there is no violation yet. It is just a list. But if because he is top of the list, then the police now say we go and apprehend A. If they go and arrest him without a warrant, there is something wrong with that, right?
Yes, Your Honor.
If they go to his home and barge in without a warrant, there is something wrong with that.
Yes.
So, my point is, it is not per se the list. There has to be an affirmative act by the police forces that qualifies it to be an illegal act. So I think the government is saying the list is no different from the use of confidential agents. And the reason I bring that to you is, unlike CMC, the circular, the statistics that I referred to, deaths, surrenderies, or even arrests without deaths, you cannot, I think, parse it in a way to trace it to whether it was part of a list or not. So I would like, maybe you can respond now and cover it in your memo.
Yes, Your Honor. Your Honor, if we're going to talk about a theoretical list, Your Honor, perhaps I agree with the Honorable Justice, Your Honor, that there's nothing wrong, Your Honor. But in this particular list that's being made in San Andres Bukid, Your Honor, once a person is in the list, he's hunted down, Your Honor. We have multiple victims who were killed, Your Honor, because they were in the list, Your Honor. So, in terms of the list that we cited in our petition, Your Honor, this is what is happening, Your Honor. Once you are in the watch list, that is considered a kill list, Your Honor.
Just cover it in your memo. I have
Yes,
no
Your
further
Honor.
questions,
Yes, Your
Chief.
Justice De Castro. In your opening statement, you mentioned that you object to the use of the words negate and neutralize.
Yes, Your Honor.
Are these the only provisions in this circular that you are objecting to?
No, Your Honor. We are objecting also to the circular insofar as it radically alters the mandate of the police. Instead of conducting investigation for purposes of prosecution and conviction, it refers to compilation of names for the purpose of neutralization and negation. Instead of giving proper respect to the requirement for a search warrant, it authorizes house-to-house visitations without warrant, without any approval of a judge. These are among the arguments that we are raising against the circular.
So are you objecting, since you want us to stop the implementation of this circular, do I take it that you are objecting to this circular in its entirety?
Yes, Your Honor.
So it's not only the way it is being implemented, or it was implemented in the past?
Yes, Your Honor. By its language, it expressly authorizes or can easily be construed by the officers on the ground to authorize killing and to authorize shortcuts not otherwise allowed in our system.
So you do not agree to the concept of operations laid down in this circular?
No, we don't agree with it, Your Honor.
You object to this? Are you the one
Yes.
who advocated the implementation instead of the PNP Manual of Operation?
Both petitioners have, but yes, that is true, Your Honor. We believe that the existing PNP manual and the operational procedures are more than enough to guide the police. And when those were the ones in force, we did not have the situation where thousands of people were being killed. It was only after the circular was issued that we have this phenomenon of nanlaban, that we have this phenomenon of the people being killed by vigilantes. Before this circular was issued, Your Honor, the country had never experienced this kind of thing. And that is why we are so concerned with the use of the terms neutralization and negation. It's very clear, Your Honor, no government would expressly issue anything in writing telling the police to kill. That is why we believe that those words were used as a euphemism for the term kill, because obviously they would not want to expressly use the word kill. And as we have argued previously, by using the terms neutralization especially, as it is understood by no less than the PNP chief, as he has publicly said, to mean kill, what could we expect the officer on the ground but to entertain the same notion?
So what you're saying is that this circular actually authorizes the PNP to kill?
That is one of our arguments, Your Honor, in the guise of the words neutralization and negation.
What about the provisions of this circular where certain safeguards are put in place? Like, for instance, in the concept of operation, there is here a provision that the approach will be the conduct of Project Tokhang in drug-affected barangays in coordination with local government units, particularly provincial, city, municipal, barangay anti-drug abuse councils, non-governmental organizations, stakeholders, and other law enforcement agencies. Are you saying that this is not being observed?
We are saying, Your Honor, that at the very least, the circular is contradictory and gives mixed signals to the police. While on the one hand, it does say that they should follow human rights and respect human rights and so forth. On the other hand, it authorizes negation and neutralization. On the other hand, it authorizes compilation of lists. On the other hand, it authorizes house-to-house visitations that, in our view, are inconsistent with the Constitution and with human rights.
So you do not agree to the validity of the collection and validation of information as
because of the inherent contradictions, Your Honor, that are found within the circular, we believe that it is highly questionable.
Now, what about the provision on coordination stage? Do you think also that this is just a ruse?
If I recall that part of the circular, Your Honor, it refers to the different stages in which Tokhang is to be implemented. And the process, it's a 5-stage process where it begins precisely with the compilation of lists and ends with the house-to-house visitations of those so-called suspected illegal drug personalities.
Do you have any, before this coordination stage, do you have any information as to how they validate the information gathered in the collection and validation stage?
We don't.
Do you know how they do this?
We are not privy, Your Honor, to how that information, or even if it is actually validated. While the circular says that it should be validated, we have no knowledge of how that is done or if it is actually done. As we mentioned earlier, Your Honor, if ever that is done, it is an internal process, it is not transparent, it's done in secret, and there are no external safeguards. Unlike in an ordinary gathering of evidence, it's the court that will decide whether the evidence is admissible, and that is the safeguard in that process. We submit that in the process provided in the circular, there are no adequate safeguards.
So you do not think also that the coordination stage is being followed?
We believe
it's here that the concerned police officials and stations shall coordinate with the LGUs to provide support for the activity and ensure compliance of subordinate offices.
well,
Also, the barangays, the barangay anti-drug units are also required to coordinate with local police offices and the
Even-
PIDEA and the Dangerous Drugs Board, the media. So do you you also do not believe that this is being followed?
We do not know, Your Honor, for a fact if that is being followed or not. But even if that kind of coordination is being done, it does not detract from the concerns we have on the constitutionality of the circular. Because it still does not change the fact that the circular authorizes house-to-house visitations without warrant, that it authorizes compilations of names without any adequate safeguards, and those persons whose names appear on the list then become targets of either the first barrel, which is Tokhang, or the other barrel, which is targets, high-value targets.
What about the house-to-house visitation stage? Which of these provision do you object to?
Well, the entire provision, the entire concept, Your Honor, of Tokhang, we submit offends the Constitution because it circumvents the need for a judge to issue a warrant. It circumvents the protection provided by a judge who will stand between the police and the persons and make sure that the citizens' rights are not invaded.
Can you inform the...
I'm sorry, Your Honor.
Yes, continue. Are you done? You still want to say something?
No more, Your Honor.
Can you inform the court how exactly is the house-to-house visitation being conducted?
In the experience of
you can
our...
put this in your memorandum. These are factual matters that...
Yes, I will address that in the memorandum, Your Honor.
So that we can understand what you're objecting to. And the processing and documentation stage, which of these provisions, to your mind, are objectionable?
The provision in that area, Your Honor, which states that when a person denies the visit or refuses the visit, that certain things will happen to them, that they will be referred for immediate case build-up and negation. We submit, Your Honor, that that is inconsistent with several of the rights in our Bill of Rights.
So I'll ask you to be more specific when you prepare your memorandum.
Yes, Your Honor.
As to the objectionable implementation or the provisions of this circular which you believe are susceptible of misinterpretation or misapplication.
We will do that, Your Honor.
And please do that in detail. Now, what about the upper barrel? You also object to that?
Yes, Your Honor. In essence, it is just a continuation of the lower barrel. It is based on the same practice of compilation of names. It is not based on evidence gathering of criminal acts, but rather simply names. Your Honor, the reason why we are so concerned with the circular is because it is akin to what was done in other countries where secret police compiled names. And what we have observed is that from the time this circular was issued, rather than focusing on gathering of evidence for the proper prosecution of people, bring them to court, punish them as the law provides, RPNP has been involved and has concentrated on compiling names. And as we mentioned, compiling names is very different from gathering evidence. Anyone can submit names. It could even be for personal or political reasons that a person's name will appear on the list. And that is exacerbated by the fact that not just the PNP, but even higher officials of our country have also, the President himself has issued lists, and anyone's names, as this court is aware, even the names of some judges have appeared on those lists.
Can I ask you and Attorney Butuyan to be more specific in your memorandum and show how these provisions violate human rights and
Yes, Your
our
Honor.
international commitments to guarantee human rights. Now, I also would like you to compare the Philippine National Police Manual of Operation with this circular, and why you say that is better, and why you say that the manual will suffice to address the widespread use of illegal drugs in the country. You said this is the first time that there are so many arrests, and you said there were killings because of related to the use of drugs, illegal drugs. But this is also the first time in our history that we have seen big factories, shabu factories, in populated areas, and so many barangays afflicted with whose population are seriously affected by the use of illegal drugs, and drugs peddling is quite rampant. And to show to us that the manual of operation existing would suffice to meet this serious problem that we have now about the use of illegal drugs in our country.
We will do that.
We are appalled by the so many big factories of shabu, which are in the middle of urban areas, which were undetected for long periods of time, and it's only now that we have seen that there are so many of these drug factories, and there are so many drugs are imported into the country, passing through customs, involving billions of money. How should the government address this malady, social malady of our present-day society?
We share Your Honor's concern, and we also wonder why the government is not going after those big warehouses, Your Honor.
Okay, so I'd like to see you deal with those matters in your memorandum.
We will do that, Your Honor.
Thank you.
Thank you.
Justice Del Castillo.
Can we have Dean Jokno? Good afternoon, Dean.
Good afternoon.
Just a few
Your Honor.
questions. You mentioned in your petition the phrase Minnesota Protocol.
That's in the petition of Attorney.
Can we have Attorney Butuyan then? We don't encounter this phrase very often. What do you understand by this, Counsel?
Your Honor, it is the work of acclaimed experts in the field, Your Honor. And it outlines the generally accepted investigation procedures that would comply with international law with respect to investigations that investigations on deaths, Your Honor, especially if these deaths are caused by state agents, Your Honor.
This is a UN document?
It was drafted by a panel of experts, Your Honor. And
what is our participation in this document? The Philippines, I mean, are we a signatory to this protocol?
no, this is not a protocol, Your Honor, but this is an output of a panel of experts, Your Honor, that was presented to the, I believe, to the United Nations, Your Honor.
When was this? Would you know when this was passed?
Your Honor, this is the last time that this was somewhat amended was, I think, 2016, Your Honor.
Would you know why we're not a signatory to this document?
This is actually just an output of a panel of experts, Your Honor, that's recognized under international law as a secondary source of international law, Your Honor.
How does this now relate to our case, this particular protocol?
This is the generally accepted, this outlines the generally accepted procedure of how countries should investigate deaths, especially when they result from suspicions that there is state involvement in this death, Your Honor.
You mean a death most likely caused by law enforcement
Yes, Your
agents
Honor.
like the police?
Yes, Your Honor.
And what is supposed to be the procedure that they're supposed to follow?
it's a very long outline of procedures, Your Honor, that's in the Minnesota Protocol, Your Honor. From the time that the death occurs, Your Honor, the preservation of the crime scene, the tagging, the mapping, everything is very detailed, Your Honor.
Okay, thank you, counsel.
Thank you, Your Honor.
Justice Carpio.
Attorney Butuyan, please. I have a few more questions.
Yes, Your Honor.
Attorney Butuyan. Attorney Butuyan. Attorney Jokno, please take your seat. I will ask a few questions from Attorney Butuyan. The list is prepared by the barangay chair, is that correct? List of suspects, those who are into drugs.
Your Honor, the police make the list, although they get the information from each barangay, Your Honor. They solicit the list from the barangay.
I understand that the barangay chairs are asked to prepare a list of residents who are into drugs. Is that correct?
Well, they have names, Your Honor, that they contribute to the police, Your Honor. But the list itself for the entire barangay is held by for the entire community is held by the police, Your Honor.
So the barangay chair draws up a list to be submitted to the police.
Yes, Your Honor.
Is the list prepared by the barangay chair verified by the PIDEA or by any other government agency?
I don't think so, Your Honor.
So it's a list prepared at the barangay level, that's all?
Yes, Your Honor.
Okay, so it's just the say-so of the barangay chair.
Yes, Your Honor.
So you have a list that's prepared, and the barangay chair can include his political enemies there, and nobody can exclude those political the names. I mean, he has absolute right to submit a list, and nobody can delete that at the barangay level.
Yes, Your Honor, because it's submitted in confidence, Your Honor.
Submitted in confidence.
Yes, Your Honor.
So the barangay residents wouldn't know if their names are in the list.
Yes, Your Honor, but sometimes word would come out that certain residents are included in the list, Your Honor.
But there is no mechanism for them to be delisted from that list at the barangay level.
There's none, Your Honor.
Okay. So you have a list.
Yes, Your Honor.
And then all these operations are carried out without judicial warrants, correct?
Yes, Your Honor.
And no case is filed in court. There is no prosecution. That's what you stated in your petition, correct?
No case at all, Your Honor.
And normally, the killers wear masks, and the uniformed police cordon the area, correct?
Yes, Your Honor.
And there are no police reports afterwards of the killing.
Our clients have not been...
Your clients,
no, yes, Your Honor.
the families of the deceased, of the victims, are not given police reports.
Nothing, Your Honor.
And this happens sometime between midnight and 3 a.m.
Yes, Your Honor.
And this has resulted officially in 3,800 deaths,
Yes, Your Honor.
according to the police, in legitimate operations.
Yes, Your
And there are still about 4,000 to 5,000 of deaths under investigation.
Yes, Your Honor.
Now, based on these circumstances, can we say that while if you read Memo Circular 16-2016, it may look constitutional, but in the enforcement, it is certainly unconstitutional. Can you argue that way?
Yes, Your Honor. But even on its face, Your Honor, I think CMC
Yeah,
16...
even assuming if on its face it is constitutional,
Yes, Your Honor.
it is still unconstitutional because of the way it's being enforced.
Yes, Your
Now,
Honor.
how do you justify that argument?
Because the different stages, Your Honor, the 5 stages, Your Honor, they do not, they violate the rights of the suspect, they violate the rights of the accused, Your Honor. If we compare the manual of operations of the PNP, and the CMC, Your Honor. The Manual of Operations, Your Honor, included in the step-by-step outline that the police should follow, Your Honor. Weaved into this step-by-step are the observance of the rights of the accused, of the suspect, Your Honor. In contrast, Your Honor, CMC 2016, in the step-by-step outline, Your Honor, the rights of the accused are not mandated to be observed by the police. That's why I agree with Dean Jokno, Your Honor, that the recitation of compliance with 7438 and 9165 is merely lip service, Your Honor, because if the police is really serious in having the police observe and enforce the rights of the accused, it should have been weaved into the step-by-step outlining of each stage, Your Honor.
Okay, so in your memo, discuss, even assuming that the circulars are constitutional on their face, the implementation makes them unconstitutional. Okay?
Yes, Your Honor.
Okay, that's all. Thank you, Counsel.
Thank you, Your Honor.
Justice Martirez and then Justice Leonen.
Attorney Butuyan, one of the respondents in your petition is the Philippine Drug Enforcement Agency.
Yes, Your Honor.
Correct? But in your arguments or in the allegations of your petition, you never mentioned any commission of a wrong by the PDEA or any killing done by the PDEA. Is that correct?
Yes, Your Honor.
The killings were all perpetrated by the police officers.
Yes, Your Honor.
Are you aware that the enforcement of drugs now is transferred to the Philippine Drug Enforcement Agency and it is not with the police?
Yes, Your Honor. In fact, at the time we filed our petition, Your Honor, it was the time, like 2 or 3 days after the President, Your Honor, transferred the sole authority to the PDEA. That's why we had to include the PDEA, Your Honor, for them to be included as the additional government agency that would observe, Your Honor, whatever is going to be the ruling in this court, Your Honor.
Why did you not remove, as part the respondent, the Philippine National Police?
Because, Your Honor, the police, per the statement of the PDEA, they cannot, at the time, Your Honor, they say that they cannot do it alone, Your Honor. They will still need the police, Your Honor. In fact, even now, the police are not totally out of the picture, Your Honor. They still provide auxiliary or assistance to the PDEA, Your Honor.
Are you sure of your manifestation this afternoon, that the police are still active in the Operation Tokhang of the government?
Not in the actual operation, but they provide auxiliary services or assistance
What are
to the
these
PDEA, Your Honor.
auxiliary services?
Probably intelligence, Your Honor, because
Why
that was
use
the
the word
statement.
probably? Do not use the word probably. If you're sure, if there are auxiliary services being provided by the police, do not use the word probably. What are these auxiliary services?
If I remember correctly, Your Honor, the police came up with a statement, official statement, that they would still support the PDEA in their operations, in their drug operations, Your Honor.
Have you heard of an incident where the police gave their support to the PDEA?
Nothing in particular, Your Honor.
Could you please read to us, for the record, the judicial affidavit of Sister Danyo, number 14. Why were you not bothered when AJ case has started to happen in San Andres, Bukid? Question number 14.
Yes, Your Honor. I read from the affidavit, Your Honor. Question 14. Why you were not bothered when EJ cases started to happen in San Andres, Bukid? A14. You see, in San Andres, Bukid, trading illegal drugs was rampant. You could see this happening in every corner especially in the two largest barangays, Barangay 775, which has about 16,000 plus residents, and Barangay 770, which has 15,000 plus. No single barangay is free of illegal drugs. At that time, I had a tiny steering of hope that the people who were into illegal drugs would somehow learn their lesson, be afraid, and give up their vice.
Is any of the petitioner a resident of these two barangays?
Yes, Your Honor.
What is the land area of Barangay 775?
Your Honor.
What is the land area of Barangay 775 that comprises of 16,000 plus residents?
I don't have the information at this point, Your
You
Honor.
don't have any information. What about Barangay 770? What is the land area?
We will include that in our memorandum, Your Honor.
Could you read your number one prayer for relief?
The provisional relief, Your Honor.
Read it, your prayer.
Provisional relief A. Immediately upon the filing of this petition, a writ of amparo be issued directing respondents to file within 72 hours from receipt hereof a verified return together with supporting affidavits and documents containing the relevant information required under Section 9 of the Rule on the writ of amparo.
Go to B, number one, or BI. Prohibiting respondents.
Prohibiting respondents, their officers and agents from entering within a radius of 1 kilometer from the residence, work addresses of the affected parties.
Okay. Let's go back again to the judicial affidavit of Sister Danyo.
Yes, Your Honor.
She's claiming that Barangay 775 drug trafficking is very rampant. If you prohibit police officers or the PDEA from entering within a radius of 1 kilometer, who else will be arrested in that area?
Your Honor, we are not absolutely against drug operations, Your Honor. We are only against drug operations that violate the rights of innocent civilians, Your Honor, even suspects who are killed outside of the bounds of the law, Your Honor. If the police can ensure, Your Honor, they follow the PNP manual, Your Honor, and they observe the rights of suspects and accused, Your Honor, pursuant to their own PNP manual, Your Honor, we have no objection for them to go full force on their drug operations in these areas, Your Honor.
Barangay 770, you said one of the petitioners is a resident.
Yes, Your
Of
Honor.
Barangay 770.
Yes, Your Honor.
Do you mean to say that police operations or the PDEA operations will just be limited to one house, to the exclusion of all other houses? How do you now measure the 1 kilometer radius? How do you now exclude the residents of one of the petitioners residing in 770? So that the other houses will not be included in the 1 kilometer radius.
Your Honor, our wish list is that the police should first get their acts together and institute a procedure that would reconcile legitimate drug operations with observance of the rights of people, Your Honor. Even if, for instance, Your Honor, they're operating against a drug addict, Your Honor, they should observe. The drug addict would have rights under our Constitution, and they should observe those rights, Your Honor.
So you mean to say the PDEA or the police will first inform one of the petitioners who is a resident of 770, please leave your house. We're going to conduct a buy-bust operation in the house of your neighbor. Is that what you're trying to tell us?
No, Your Honor.
So how then will the police be able?
Your Honor, we want them to follow their own PNP manual because the PNP manual is very detailed on how every kind of police operation should be conducted
So in this
properly.
particular situation, what particular rule in that manual must now be followed?
Your Honor, there is a section for every even a drug by bus operation. It's very detailed, step by step, Your
We're
Honor.
talking here of the 1 kilometer radius that you're asking. This is the house of the petitioner.
Yes, Your Honor.
This is the house of the suspected drug pusher.
Yes, Your
How do you now measure the 1 kilometer radius?
Your Honor,
Excluding the house of the petitioner.
Your Honor, we base this prayer for relief on the Murillo case that we filed and where we obtained a 1 kilometer radius protection, temporary protection order from this honorable court, Your Honor.
You were talking also of a jurisprudence from Chile or Brazil
Yes, Chile
or
or
Argentina.
Yes, Your
Could you
Honor.
cite that in your memorandum?
We will, Your Honor.
Thank you.
Justice Leonen.
Attorney Butuyan, your clients are mostly coming from the RGS sisters, is that not correct?
Yes, Your Honor.
RGS, and what does RGS mean again?
Religious of the Good Shepherd, Your Honor.
Religious of the Good Shepherd. These are Catholic nuns?
Not all of them, Your Honor. Some of them are actually community workers connected with the RGS, Your Honor.
Okay, you mean that they are Catholics, all of them?
Yes, Your Honor.
And this is not a political party, I understand.
No, not.
They are not campaigning for or against any presidential candidate or any senatorial candidate now,
No, Your Honor.
now or in the future. Is that not correct?
Yes, Your Honor.
What is the role of the RGS sisters in the community that you are representing?
Originally, they had a religious purpose in the community, Your Honor.
So they are no longer religious.
They are religious, Your
They
Honor.
are religious. So what is their actual mission in the community?
To spread the word, Your Honor.
Spread what word? Constitution?
The Christian word, Your Honor.
Yes. And how do they do that, if you know?
They,
By attending to the needs of the community where they are located. Is that not correct?
yes, Your Honor. And I think they also do Bible studies, Your Honor.
Yes, and like Christ, if I know Christ, he actually went to communities and looked at their problems and attended to the problems the way that the best that they could in order to show Catholicism as lived. Is that not correct?
Yes, Your Honor.
Yes. So I still remember my Catholic upbringing. Is that not correct?
Yes,
well,
Your Honor.
you may not answer that. In other words, I am asking, what is the motive of the RGS sisters in giving sanctuary and succor to all those that have been victims of what you allege to be systematic violence?
They want to help the community, Your Honor, the members of the community, Your Honor.
Now, why is it not the community themselves that have filed this case?
Your Honor, these are really very poor people, Your Honor. They don't even have the money to come to even just attend meetings with their lawyers, Your Honor.
Yes, and you describe their houses as almost a box. Is that
Yes,
not
Your
correct?
Honor. Yes,
In
Your Honor.
fact, there is an incident. I think your first petitioner is actually about two, I think 19 and 20-year-olds who had to leave their small house, their small box, because the sister or the cousin of one of them just gave birth. Is that not correct?
Yes, Your Honor.
Yes. May I know who this is? Anyway, it's in your pleading. In other words, they are there in order to be the voice of the community. Is that not correct?
Yes, Your Honor.
Yes. And the community that they represent do not have the resources. I think you mentioned that.
Yes,
Is that
Your
not
Honor.
correct? They do not have the resources even to pay for your transportation or the transportation for them to go to your office. Is
Yes,
that
Your
not
Honor.
correct?
Yes, Your Honor.
And to a certain extent, any petition filed with the Supreme Court, or any court for that matter, the petitioner is a majority of one. Is that not correct? In other words, it can get the petitioner for the right reason and the right law, the right interpretation of the law, can get the coercive mechanism of this entire state to move in their favor. Is that not correct?
Yes, Your Honor.
And the Bill of Rights is actually there to protect the minority, the downtrodden, the people that do not have the resources, that those that are drowned out by the majority voice. Is that not correct?
Yes, Your Honor.
So, in other words, it may be that the majority of the Filipino people might want to get rid of drugs. Perhaps even your client want to get rid of drugs. But there are certain ways by which this procedure is being done that actually hurts the minority more than it helps them. Is that not correct?
Yes, Your Honor.
Yes, and it is this minority, for the voices of this minority that you are amplifying in your petition. Is that not correct?
Yes, Your Honor.
Yes, I just wanted to be clear because at a certain point we will have to assess whether the factual allegations made by your clients have underlying motivation, such as, for instance, they are made by the Dilawan or perhaps people that are against this administration, correct?
Yes, Your
As
Honor.
a matter
not
of
at all.
fact, I was attracted by one sentence in your pleading. In your first sentence, you did mention that many of them voted for the current president. Is that not correct?
That's true, Your Honor.
And they are willing to execute an affidavit to do that, although, of course, they have waived their sanctity of the ballot. Is that not correct?
Yes, Your Honor.
Yes, okay. Now, there is a list you mentioned, that list generated for purposes of this program called the Tokhang. Is that not correct?
Yes, Your Honor.
Yes. Is it easy to get into the list?
It's easy, Your Honor.
All you need is somebody in the community telling on you. Is that not correct?
Yes, Your Honor.
Yes. And of course, the police, they have their own way of validation because according to the rules on Tokhang, there is some level of investigation that goes on in order to determine whether or not a person must be in the list. Is that not correct?
On paper, yes, Your Honor.
Yes. How does one get out of the list?
There's no procedure, Your Honor.
There is no procedure. In other
Yes.
words, the CMC circular and the department manuals of the DILG as well as the police manual have no provision in order for one person who is in the list to actually know that they are in the list and to actually have their name removed. Is that not correct?
Yes, Your Honor.
Has any of your clients tried to get out of the list, that list?
Yes, Your Honor.
And what happened?
They were not entertained by the police, Your Honor.
They were not entertained by the police
Yes, Your
because?
Because the police were not allowing them to...
You mean there is no administrative procedure for getting your name off a list that says drug suspects?
There's none, Your Honor.
There's none, okay. Now, labeling is one function that legal fiction does. For example, when you are convicted of a crime, you are a convict. Is that not correct?
Yes, Your Honor.
That you have committed that particular crime. Is that not correct?
Yes, Your Honor.
And labeling, for all intents and purposes, signals to the society that certain things can visit you, certain consequences, such as, for instance, when you are said to be a convict, then either there is conviction or the payment of a fine. Is that not correct?
Yes, Your Honor.
Yes. Now, in terms of the list, what is the title of the list? What is the label given to the individuals that are in the list? Are they called drug addicts, drug pushers,
they're
drug
called-
personalities?
Drug addicts, Your Honor.
In fact, the CMC circular uses the term drug personalities. Is that not correct?
Yes, Your Honor.
Yes, and when you are said to be drug personalities, the normal cultural and political consequences of that label certainly visits that person. Is that not correct?
Yes, Your Honor.
Yes. Were you the one that mentioned that there was a statement by the DOJ secretary regarding drug addicts?
Regarding the...
Drug addicts, whether they are still human or not human.
Yes, Your Honor.
According to you, what did the DOJ secretary say?
He said that drug addicts are not humans, they're not part of humanity, Your Honor. So there's no crime against humanity in killing them, Your Honor.
So, even if you may not have known that you were in a list of known drug personalities, there is a signal given to the community, perhaps not only to law enforcement, but politically, that you are a dangerous creature, that you should be shunned, that you should be abhorred, and perhaps that you are less than human. Is that not correct?
Yes, Your Honor.
There are certain kinds of labels that are put on you that make you less than human. Is that not correct?
Yes, Your Honor.
Of course, it can be done by your friends or your enemies, and that's understandable when you live in a society. Is that not correct?
Yes, Your Honor.
But when it is done by your government, when there is an official process that does that, then would you say that there is some fundamental right that is violated?
There is, Your Honor.
What is that fundamental right that is violated?
The presumption of innocence, Your Honor.
Your presumption of innocence, could it be your right to life?
Even that, Your
Could
Honor.
it be Article 2, Section 12, that the human dignity should be respected by the state? The state shall respect the human dignity of every person. Isn't that a provision in the Constitution?
Yes, Your Honor.
Yes. So therefore, giving a mistaken label without any procedure for you to get out of that particular label, for that label to stick even among official circles, can be a dangerous thing. Is that not correct?
Very dangerous, yes, Your
Very
Honor.
dangerous.
Okay.
Because it is entirely possible that one drug list will contain the name Marvick Leonen. Is that not correct?
Yes, Your Honor.
And if it contains Marvick Leonen, it says drug personality, then therefore my entire reputation will be gone. When I visit a community, it is possible that a police officer might accost me because there is already the suspected idea that I am a drug personality. Is that not correct?
Yes, Your Honor.
Have you seen my name in the San Andres booking list?
Not yet, Your Honor.
Yes, because I might need a lawyer to get my name out, but if you said that it is not possible to get it out, then it should not be there. Okay. In any case, perhaps you can, of course, the Solicitor General will have to respond to this kind of an argument that getting in the list itself and not getting out, I read it in your pleadings, it is itself a violation of a constitutional right. Okay.
Yes, Your Honor.
The rule of law is not the responsibility of the police alone. True or false?
Yes, Your Honor.
Yes. The rule of law is not the responsibility of the police and lawyers alone. Is that not correct?
Yes, Your
The
Honor.
rule of law is not the responsibility of the police, the lawyers, and the courts alone. Is that not correct?
Yes, Your Honor.
As a matter of fact, the fundamental pillar that assures the rule of law is community.
Yes, Your Honor.
Isn't that correct? Because
Honor.
to a certain extent, you may have all the best policemen and women, you may have all the proper judges, you may have very competent lawyers, you may have very competent prosecutors, but information of what is happening on the ground in their communities will always come from the people themselves. Is that not correct?
That's true, Your Honor.
And with this kind of an idea, isn't it legitimate that the police ask the citizens about information as to people who are dangerous in their area? Is it unconstitutional per se that people go to police and tell them, this person is suspicious, this person is dangerous? Is it unconstitutional by itself that the police actually ask people, help us in terms of this war on illegal drugs? Is that unconstitutional?
Not by itself, Your Honor.
So therefore, Tokhang is not unconstitutional in that sense, correct?
It is, Your Honor.
Why is it unconstitutional?
Well, because the stages, Your Honor, the stages that are outlined step by step, Your
But
Honor,
I
that's
thought
not...
you said that community participation is important. That
Yes, Your
community
Honor.
participation in terms of rooting out all these evils, you know, the drug problem as indicated by Justice De Castro concerns us too. We have seen the large discoveries of shabu and many other. There was the importation of 6 billion worth of shabu, if I'm not mistaken. So we are concerned about what is happening. And daily in our deliberations, we see a lot of convictions in terms of buy-bust, etc. So we know that the drug problem is out there. But you cannot solve it simply by the police doing their own thing. They need the informants. They need the community. So therefore, what is so wrong about asking for information from the community?
Your Honor, if it blackens the reputation, for instance, of a particular person, Your Honor, there should be an opportunity for that person.
But to be accurate, at a certain point, it will have to blacken it because a person will say, eto po, nagtutulak ng droga sa amin. Therefore, the police will try to investigate that person. Is that not correct?
Yes, Your Honor.
And for that moment, that person's reputation to the police is, of course, suspect. And what they do is actually investigate. Is that not correct?
Yes, Your Honor.
Yes. Isn't that in the CMC order that the police, upon receiving a name, will do a certain level of investigation? In fact, that is part 1. Is
Yes,
that not correct?
yes, Your Honor. But in part 1, Your Honor, there's only a 1-week window for the police to conduct their evidence gathering, Your Honor.
Isn't that very good? Because then the police is told to be efficient. I mean, what should the window be? 5 years, 10 years,
Your
100
Honor,
years?
the CMC identifies that there are 1.8 million drug personalities in the country, and there are 175,000 policemen, Your Honor, and that would entail, per our estimation, 10 drug personalities to be investigated by each policeman in just 1 week, Your Honor.
So it is only the period. So if it is now amended and they say 2-month period, that would be all right.
No, Your Honor.
3 months.
No, Your Honor.
Forever. So
Well-
the police are told you are given a name by a member of the community, you may dilly-dally, you may not act on it immediately. So what does that do with community relations and the police?
Your Honor, if the police would have information with regard to a particular person, there is a procedure under the law. They should file the case because that is
Yes,
how...
but before they file the case, before a police goes to a prosecutor to actually do the report in order for the prosecutor to file, they have to discover the evidence, they have to preserve the evidence and maintain the evidence, and then record it and pass it on to the prosecutor. Is that not correct?
Yes, Your Honor.
That's criminal investigation, is
Yes,
it
Your
not
Honor.
true? And criminal investigation starts with a lead,
Yes, Your
an
Honor.
idea, a fact. And
Yes,
that
Your
fact can be a member of the community of San Andres Bukid going to Station 6
Yes, Your Honor.
and telling the police there, kapitbahay ko nagtutulak ng droga.
Yes, Your Honor.
Correct?
Yes,
So,
Your Honor.
isn't that tokhang?
No, Your Honor, because what happens is that the police act on the information that they have, Your Honor, without going through, they would consider the persons they build information on, Your Honor, just on the basis of the information that they have, without validating, without filing the necessary case. It's them who acts on the basis of the information that they themselves gather, Your Honor.
They act on it by investigating on it.
Not only investigating,
They
they
act
would
on
go...
it by actually visiting the suspect
Yes, Your Honor.
and knocking on the door of the suspect.
Yes, Your Honor.
Isn't it perhaps the police saying, kung sakaling nagtutulak ka ng droga, wag mo na ituloy? Would there be something unconstitutional about that?
The problem, Your Honor, is that when they go, they already have evidence with respect to this particular person. And
Yes.
per the wording of the CMC, Your Honor, the evidence that they have is enough to, for them to consider the person that they visit as a suspect, Your Honor, under
Yes.
the definition of the law.
Of course, as a suspect. But when they knock on the door and it opens, the police will say, kung maari lang, kung sakaling drug pusher ka, wag mo na ituloy.
But the wordings of the CMC, Your Honor, would require the police to inform the
As a matter of
person
fact,
visited.
we actually do not know what the police say. Is that not correct? Because
Well,
your
indeed-
cases are with respect to what happens at the middle of the night, as you said, from 10 to 3,
Yes, Your Honor.
where it may no longer be tokhang, but something else. Is that not correct? But still, according to your petition, you are attacking the provisions on tokhang.
Yes, Your Honor.
Yes. How is that related to the incidents that happened from 10 to 3? You mean to say that is still tokhang?
That's still tokhang because it is an operation that's pursued because of the issuance of the CMC, Your Honor.
So where in the CMC does it say that between 10 and 3, you assault a house, and inside the house, it should have a perimeter guard of policemen?
This
And that-
started only after the issuance of the CMC, Your Honor.
which was after the elections. Is that
Yes,
not
Your Honor.
correct?
Yes, Your Honor.
And when the president says, let's be aggressive about illegal drugs. Is that not correct?
Yes, Your Honor.
Yes. Perhaps you can cover the balance between community participation and what is constitutional, and why you will say that these activities that are happening in San Andres Bukid would be unconstitutional in the light of the need for community participation. By the way, Counsel, is the drop box still existing in San Andres Bukid?
We didn't raise that, Your Honor, because we didn't encounter any such, that was raised by Dean Jokno, Your Honor.
Okay. By the way, if one's name is found in a list,
Yes, Your Honor.
can it be subject to a petition for habeas data? In other words, can the police be the subject of, be the respondent in a petition of a person who's found himself or herself in a list, asking for the basis for putting that person in the list?
If I remember correctly, Your Honor, that, yes, it is, Your Honor.
So there is a legal remedy, is that
Yes,
not
Your Honor.
correct?
Yes, Your Honor.
Okay. By the way, Counsel, are you familiar with Makapili
Makapili, the Japanese...
during the Japanese
yes, Your Honor.
occupation? Can you describe the operations of the Makapili at that point
Well,
in our history?
it would involve a civilian wearing a
Anonymous.
a basket, Your Honor, with only his eyes open, Your
Yes.
Honor, and he would pinpoint to particular residents in the community, Your Honor, as rebels, for instance, Your Honor.
otherwise known as furtive fingers in our cases. Is that not correct? Furtive fingers, correct?
Yes, Your Honor.
Okay, I have no further questions, Your
Attorney Butuyan, please just stay, and we will be soon be wrapping up the session. In reference to the question of Justice Leonen, and I would want to ask you to respond to this in the vernacular so that you can be understood, because our discussions have been quite very fast using technical language. Tatagalogin ko po para maintindihan. Kung totoong yung mga kliyente mo na mga residente ng Santa Ana ay natatakot dahil nanganganib, animo ang kanilang buhay dahil baka nasa listahan sila, hindi nyo pa po pinag-isipan na humingi ng petisyon o na mag-file ng petisyon ng writ of habeas data upang masiguro nga na ang mga kliyente mo ay mananatiling sigurado ang buhay?
We will discuss this with our clients, Your Honor.
Okay.
Okay.
So, pangalawa, kaya mo bang i-kumpara ang isang sham investigation, hindi 9, SHAM, yung pakunwaring investigasyon sa isang good faith or genuine investigation ng isang potential unlawful killing, which is what is in the Minnesota Protocol, no? Hindi ko pa nga sinasabing EJK pero potential unlawful killing. Kaya mo bang ihambing yan, Ginoong Butuyan?
Opo.
Paano? Kung kaya mong magsalita sa vernacular, pakipaliwanag nga po kung ano ang standard sa isang good faith investigation at isang sham investigation.
Kailangan po yung katawan ng patay ay hindi gagalawin at pupunta ang investigador para i-document yung lahat ng ebidensya na nandun, yung sitwasyon ng katawan, yung mga basyo ng bala, yung lahat ho na nandun. Kailangan hong hindi gagalawin ho ng pulis. Pero kung ginalaw ho ng pulis yung katawan, na wala pa hong investigasyon na nangyayari po, yun ho ay isang sham na investigasyon kahit na ho gawa na nila ng report pagkatapos na ho natanggal na yung katawan sa pinangyarihan ho ng krimen.
Ano pa? Tuloy-tuloy mo hanggang sa dulo ng pag-close ng investigasyon.
Kailangan pong i-secure yung pinangyarihan po ng krimen. And kailangan din po magkaroon ng record ng lahat ng tao na pupunta doon sa may pinangyarihan ng krimen. Pati yung oras, yung araw na pagpunta nila doon, pati yung mga ebidensya na kinuha nila doon. Lahat po ng ebidensya na nakukuha sa pinangyarihan ng krimen ay kailangan hong i-preserve at i-analyze po ng mga forensic experts po. Kailangan din pong ma-interview yung mga testigo tungkol sa pangyayari. Kailangan hong kunan ng mga statements yung mga testigo. Kailangan hong malaman yung kung ano yung naging galaw ng biktima, pati yung kanyang mga kausap at mga pinag-usapan, mga dokumento, mga financial transaction, at kung merong CCTV footage po at photographs, kailangan pong makuha rin ho yung mga yon. Detalyado po yung listahan ng Minnesota Protocol kung ano po yung mga gagawin para ho ang isang investigasyon ay totoong investigasyon at hindi kunwa-kunwaring investigasyon lamang.
Kailangan bang ang media pa ang magdala sa atensyon ng publiko ang isang pagkamatay na hinihinalang EJK bago ito imbestigahan? O dapat nararapat na kaagad pag nalaman ng otoridad ang pagkamatay ay sisimulan na kaagad ang imbestigasyon?
Hindi na ho kailangan ng media po, pero kapag meron hong, kapag ito ho ay isang drug operation po, meron pong procedure na kapag nag-inventaryo ng nakuhang droga po, meron pang mga independent na mga tao na kailangan ng ilang presensya. Kasama ang PIDEA, kasama ang opisyal doon sa may komunidad, kasama ang kung buhay yung biktima or yung representative niya kung patay na siya, kasama rin ho yung media.
So, tama po ba na ang bangkay ng isang pinaghihinalang potential unlawful killing ay bigla na lang dadalhin ng pulis sa isang punerarya o sa isang ospital?
Hindi ho tama, lalo na ho sa San Andres Bukid na kung saan na-discover na ho namin na meron hong paboritong punerarya yung pulis na dinadala nila. May dokumento ho kami nito na sinasabi ng pulis na ito dalhin nyo sa particular na punerarya po.
Tama po ba na ang dahilan sa pagkakadawit ng isang biktima ng potential unlawful killing po ay nakuha sa isang Facebook post matapos mangyari ang pagkamatay?
Hindi ho tama.
So saan dapat manggagaling talaga ang ebidensya upang ang isang tao ay maging isang suspecha na isang drug personality?
Nag-uumpisa ho sa police. Police ho yung dapat nagkakalap ho ng lahat ng ebidensya. At lahat ho na ito, kung namatay, kailangan ho nilang isubmit sa prosecutor po.
Pag namatay ba ang mga husgado, immediately sasabihin, presume natin na ang pagkamatay ay dahil sa isang regular discharge ng official function ng pulis. Immediately po ba ipre-presume namin na ang depensa ng self-defense ay automatically mag-a-apply? O yung sinasabi na ang pulis ay nanganganib ang buhay, kaya minarapat niyang unahan ang pagbaril sa namatay?
Hindi po. Wala hong presumption of regularity kapag ang isang tao ay namatay sa kamay ng mga pulis. In fact, obligasyon ho ng pulis na pruwebahan na siya ay may mga meron talagang circumstances na kailangan niya talagang idepensa yung sarili niya, Your Honor.
Maaari rin po ba na ang presumption ng regularity of discharge of the regularity of the discharge of the police function ay i-apply din sa isang taong nakakulong na namatay sa loob ng selda?
Hindi ho, wala rin hong presumption of regularity pag ganun po.
So, pag sinasabing lahat ng mga police killings naman, pwede na nating automatically, generally apply ang presumption of regularity, may basihan po ba sa konstitusyon o sa mga batas ang ganong pahayag?
Wala pong batayan yung ganong klaseng posisyon. And in fact, yun ho ay isang pruweba na may impunity na nangyayari sa ating bansa.
Hindi po ba ang defense na ang exempt justifying circumstance o yung nagpapawalang sala na sirkumstansya ng self-defense po ay iniisip po nating isang rare occurrence kasi ang una pong obligasyon ng mga pulis ay hulihing buhay ang mga personalidad na sasangkot sa krimen.
Tama po.
So kung marami na po tayong nasasabi natin na nanlaban, na sinasabi niyong maaring libo-libo na po, ano po ang masasabi nito? Magkakaroon na ba tayo ng basihan upang masabing mayroong pong sistema o pattern na tayong makikita sa mga nangyayari?
Meron na pong pattern.
Paano niyo po masasabi ito?
Dahil ho kung sinasabi ho ng mga kinauukulan na niwalang EJ case na nangyari, tapos wala hong investigasyon na nangyayari, meron hong pattern talaga, meron hong talagang policy ang gobyerno na itago ho yung lahat ng mga nangyari sa mga pagpatay ng mga pulis na libo-libo na ho nangyayari.
Ngunit marami naman po nagsasabi dahil sa matinding takot po ng mga nasasangkot sa droga ay mayroon na pong kapayapaan sa ating mga komunidad. Tama po ba ito?
Kapayapaan po ng patay yung sinasabi ho nila. Hindi na ho nakakapagsalita yung mga mataong pinatay nila. Pero wala hong kapayapaan. In fact, mas lalo nga hong ang komunidad ay hindi mapayapa dahil lahat ho ay takot.
Kung sakaling mapawalang bisa ng korteng ito, ang sinasabi niyong circular na inisyu po ng PNP ukol sa tokhang, ay paano po yung mga pulis na sinunod yung akala nilang tamang pagbasa ng circular na ito na ang pag-neutralize o ang pag-negate ay pagpapayag na kumitil ng buhay nang hindi ayon sa requirement ng self-defense?
Hindi ho depensa yung hindi nila yung sasabihin nilang sinunod lang nila yung CMC circular po.
Ibig sabihin mo, hindi po nila maipresent ito sa kahit anong korte upang mapawalang sala ang mga pulis na sumunod lamang sa akala nilang tamang direksyon?
Hindi ho magiging epektibong depensa yung ganong klaseng depensa po.
Kung halimbawa usigin po sila ng kanilang mga kamag-anak, na mga napatay nila, hanggang ilang taon sila pwedeng usigin ng mga ito? Ano po ang prescription period para po sa, kung sinasabi niyong murder ito, natawag niyo nga pong murder, gaano katagal po ito?
Kung tama po yung pagkaalala ko, parang 30 na taon po.
30 taon po. Maari po ba silang, yung mga nasa ay pwede po ba silang lumipad at mga ibang bansa upang makatakas po sa pag-uusig na ito?
Pwede ho silang lumabas ng bansa pero hindi ho mawawala yung kanilang liability ho sa krimen na nangyari at ginawa nila.
Ilagay po natin ng isang bagitong pulis, hindi po masyadong nakakaintindi, ay sumunod ayon sa kanyang pagkakaunawa. Sabihin po natin na 27 anyos po siya, yung iba naman po ay 35. Ibig sabihin mo po hanggang 60 plus years old na po itong nasa 35 ay maaari pa ho siya bang kasuhan?
Opo.
Maari po ba nating sabihin na ang kailangan ng komunidad na kapayapaan upang mawala ang problema ng droga ay pwedeng solusyonan ng Oplan Tokhang?
Hindi po.
Bakit naman po kung mayroon naman pong mga naniniwala sa Oplan Tokhang?
Sa mga pangyayari po, mas lalo hong nagiging maligalig at magulo ang ating lipunan ho. Sa tingin ko po, yung paglago ng droga ay isang problema rin ng kapulisan. Mga pulis ho na nasa mga komunidad natin, alam ho nila karamihan yung galaw. Kung lumalago ho ang droga, meron hong kapabayaan yung mga pulis sa pagsolba ng krimen, sa paglago ng droga sa kanilang mga jurisdiction.
Ibig sabihin mo ba, mayroon silang obligasyon ayon sa batas na habulin talaga ang magtutulak ng droga at nagmamanufacture ng droga, ang mga utak at financier ng industriya ng droga?
Yun ho yung dapat unang solusyon na gagawin nila para hindi ho lumago at lumala ang problema ng droga sa ating lipunan.
Hindi ka nag-o-object sa ganito. Gusto mong i-prioritize ng pulis ang mga ganitong paghabol?
Opo.
Pero ayon sa'yo, dapat ayon sa Manual of Operations ng PNP.
Opo.
Sapat na po ba ito?
Sapat na sapat po. In fact, napakaganda ho ng PNP Manual of Operations. Endorso pa ho ito ng Commission on Human Rights. Napakadetalyado ho ng lahat ng steps na gagawin ng bawat pulis sa lahat ng klase ng police operation po.
Dun po sa Minnesota Protocol na binabanggit nyo, at doon naman po sa pagkakaintindi natin sa batas, maaari po bang kahit hindi pa ho nasasakdal sa hukuman, ay mabigyan na po ng blanket na pardon or pawalang sala ang lahat ng susunod sa isang bagay na ultimately, maaaring sabihin namin ay unconstitutional. Pwede po ba ito?
Hindi po pwede.
Ibig sabihin mo po, ang requirements pa rin po ng tamang pag-conduct ng police operation, hindi po nasupercede nitong sinasabi niyong kina-question yung circular.
Hindi po.
Kailangan po ganun pa rin ang sundin nila, revised penal code, jurisprudence, at yung manual of operations. Yun pa rin po ang alituntunin sa batas.
Yun pa rin po.
Hindi po nababago ito.
Hindi po nababago.
Hindi po nababawasan ang kabigatan ng mga anomalya na maaring mangyari dahil lamang mayroong isang circular na in-issue si General Bato po.
Opo.
Ganun po pa ang pagkakaintindi nyo.
Opo.
Kaya niyo po bang ipaliwanag ito sa inyong mga memorandum at ganun na rin po kay Attorney Jokno? Gusto ko sana pong bigyan pa kayo ng pagkakataan, ngunit kaunti na lang po ang ating oras unless mayroon po kayong gustong idagdag, Attorney Jokno. Wala na po. So, wala na pong tanong ngayon. So, I will now ask Attorney Butuyan, please take your seat and we will now close the session. May I request Solicitor General Calida to please approach the podium for instructions. No, I'm sorry. It's okay. You can stay where you are. Solgen Calida, we will begin and resume our sessions on November 28th, Tuesday. Same session hall, of course, at 2 p.m. And the court requests you, we kindly request you to, directs you to bring the following with you. PNP General Ronaldo Bato, Chief. DILG Officer in Charge Catalino Cuy. PIDEA Head Aaron Aquino, unless I'm wrong with the names. The present Officer in Charge of the Dangerous Drugs Board. The head of the National Police Commission, and the head of the Philippine National Police Internal Affairs Service. Please indulge us in this, Solgen. Thank you very much. So with this, we will resume, and the parties are advised to be aware of what the contents of the advisory, and the Solicitor General will be given 30 minutes, to be fair, to make his oral presentation at the initial stage, and after which we will immediately start the interpellations of the public respondents. So thank you very much, and the session is hereby adjourned.